which is cognizable offense punishable with imprisonment of 3 years or more, undertaken by any person either singly or jointly as a member of an organized crime syndicate or on behalf of such syndicate in respect of which more than one charge sheet have been filed before a competent court within the preceding period of 10 years, and the court has taken cognizance of such offense.
So one charge sheet has already been filed.
No, my lord, against this petition, no charge sheet has been filed.
Anyone, if there are 4 people, if charge sheet is filed, more than one charge sheet against one, all of them are members
My
of the
lord, no charge sheet has been filed against any of the petitioners.
No charge sheet filed against
No, my
anyone?
lord.
Investigation is going on.
No, my
Then
lord.
how 111
Yes, my
are you
lord.
adding?
This is the case of the petitioner.
How are you adding 111?
Yes, my lord.
How are you adding 111? 111 can only be added if there is a one or more charge sheet against any one of that group. Petitioners contend that there is a land dispute and they have been falsely implicated in a series of cases. They also contend that the investigation is being conducted in a biased manner. They pray for anticipatory bail. Learned lawyer for the state opposed the bail prayer. It is contended that petitioners have criminal antecedents. They had threatened the de facto, they are members of an organized crime syndicate who threaten who are threatening landowners, who are extorting money out of landowners under the they are members of a gang of land grabbers who extort landowners under the threat of forcible occupation of their lands. We have considered the materials on record. Statement of the de facto complainant is a landowner. He alleged petitioners had threatened them, had threatened them had broken his had encroached on his land and broken the boundary wall. They demanded 5 lakhs, failing which they would take over the land forcibly. The aforesaid allegations unequivocally disclose involvement of the petitioners as extortionists and prima facie disclose the involvement of the petitioners as extortionists and land grabbers. A series of other similar criminal cases are pending against them. Interim bail granted to the petitioners have been cancelled. Taking note of their criminal activities, interim bail granted to the petitioners in another case has been cancelled. In light of the aforesaid circumstances, we are of the opinion this is not a custodial interrogation is not necessary, and this is not a fit case to grant anticipatory bail. Reject.
Grateful.
It's necessary. Reject kuch nahi. Next. Next.
But I for the petition. But 498, 326, 307 of the Indian Criminal Code.
Petition regarding 326 allegation, there is no medical report as the victim was medically treated by a local doctor. The incident was occurred on
No medical report.
no, as the victim was medically treated by the local doctor. The date of incident is 26/9/24.
We have considered the
after
materials on record.
10/24.
Allegation of physical assault is not supported by medical papers. It is contended that the victim was treated by a local doctor. Whether the injury is life-threatening. Oh, this is for 85, 498.
Yes, 498, 326, 307, 4 years of marriage.
Allegations of cruelty are general and omnibus. Accordingly, we are inclined to grant answer. Next.
I beg to appear on behalf of the petitioners, my lord. The allegation of the, in the FIR that at least 60 years back, 58 years back, my predecessor has sold some land to someone. And in spite of the knowledge, this petitioner has sold the land to the petitioner number, to the accused number 1. Absolutely civil in nature regarding land dispute. Petitioner number, accused number 1 is already endorsed on bail by an order of this coordinating bench of this court. I have annexed the order of the anticipated bail of the accused number 1. Annexure P2, page number 17, my lord. With a clear finding that a matter is absolutely civil in nature. Paragraph number 4. The FIR maker is has disclosed himself to be the power of attorney holder of that alleged owner. Even the actual owners have not come for making any FIR. The small quantity of land, and we don't have any knowledge actually because it was alleged to have happened.
He is the purchaser of the land.
They are not the purchaser, they are the seller. The purchaser has been granted bail because he is a bona fide.
Uday Ghosh?
He has been
Yes.
granted bail.
Oh,
Now they are the seller.
all right.
They have,
We have,
they have forged documents, there is a bail order report.
yes, we have seen. Petitioners submit that the dispute is civil in nature. Co-accused Uday Ghosh has been granted bail. Bail or anticipatory bail?
Mandatory bail and bail.
Anticipatory bail. They pray for similar relief. Learned lawyer for state submit. Petitioners had forged documents and falsely claiming themselves to be owners of the land. They sold the land to Uday Ghosh. He does not, they do not stand on the same footing with Uday, who has been granted pre-arrest bail. We have considered the materials on record. De facto complainant is the power of attorney holder of the owners of the land in question. It is alleged that the petitioners had made manufactured forged document and falsely claiming to be owners, transferred the land for valuable consideration. Co-accused Uday Ghosh is the purchaser for value and has been granted pre-arrest bail. Petitioners do not stand on the same footing and with Uday Ghosh. In view of the nature of the crime, we are not, we are of the opinion this is not a fit case to grant answer. Yes,
19, just I want one day accommodation. 19 is the
Same. Same person, na Budhu Ghosh.
Same legal year.
Same case or different case?
Same land.
But different case.
Different case.
Here Uday has not been granted answer.
Yes.
Here also Uday has been granted.
Yes. I have annexed the
Same order.
of that. Grateful, my lord.
Next.
One.
21.
Conviction is under section 4 of the POCSO Act, 20 years.
Who is the victim? Victim.
Victim.
That tarike, who? PW what? Victim.
You kindly see the statement of the.
Where is the judgment?
They have not annexed it.
There's the problem.
Judgment is.
What judgment is here?
Not of the by copy.
Monday, copy of the judgment be placed on record. How did you file? How the appeal was admitted without a copy of the judgment?
Of the advocate on record.
What you are saying, you are not the advocate on record.
I approve.
Really? If you want to make the circuit bench a piece of mockery, go on doing it. But if you want to get the respect of a high court, please come up to that standard. You are a person regularly appearing before us, and you are saying, I am not the advocate on record. When you have briefed, you should have told them that this is not the way in which. Huh? He doesn't know. If I have the final report judgment.
Lordship, kindly sees only the sentence, sentencing.
Sentencing portion is there.
Enter judgment is not there.
Let them file it. How this has come up for suspension of sentence?
You find prior.
You are asking for suspension of sentence. Really? Really? Have some sense. Some sense, sir. It really pains us that we have officers of the court like you. It's barred by limitation.
No, it was admitted.
What?
Section 5 was allowed.
Oh, section 5 allowed is admission. Brilliant.
I think was admitted.
Yeah. Admit করেছি judgment নেই admit করেছি file supplementary affidavit. Supplementary affidavit enclosing copy of judgment be placed on record Monday. You cannot make them speak. Cannot. Just not. Yes, next matter.
22.
I have a statement.
Yes.
My second application.
Huh?
Conviction, principal, father-in-law and brother-in-law, accidental death, husband also died. And
There's this dying declaration.
Yes, my lord. Page, my lord, 41. No. Page 41 of the page. 41, 42 and 43, my lord.
We have considered the evidence on record. Deceased wife made a dying declaration implicating the appellants, Exhibit 12. The declaration has been made in presence of the treating doctor, Exhibit PW9. In light of the aforesaid clinching evidence, as the sentence is one of life imprisonment, we are not inclined to suspend the sentence. Paper books, TCR has arrived, paper books within 8 weeks.
Great.
Yes, next matter.
Hello. 23, I appear for the petition.
Yes.
Lord, appeal against conviction, my lord.
24 admitted.
The last occasion, my lord, your lordship was pleased to call for a report as to whether any other accused, any other convict has also filed an appeal on.
কি হলো?
Twenty-three is my lord Jamir Hussain.
Correct. Who is in 24?
Lord, 24, the advocate on record, Mr. Devashish Mukhopadhyay, but he is not here.
Huh?
Mr. Devashish Mukhopadhyay is the advocate on record.
ওটা কি ইন টাইম ইনফর্ম আছে?
Yes,
একটা অদ্ভুত লোক ভাই। When we ask you something, your attention should be here, not there. Appeals are in time informed. কেন দেখে দিচ্ছ না? Your appeal 48 days delay.
my lord Jamir Hussain.
Ekramul.
No, my lord, I am Jamir Hussain, 23.
All right. কিন্তু কোনো রিপোর্টই নেই।
It was filed within time, my lord.
হ্যাঁ, ইন টাইম ইনফর্ম। জামির হোসেনটা অ্যাডমিট করো। Appeal admitted, issue usual notices, call for records, liberty to plead for suspension of sentence, হ্যাঁ? আর এখানে একটা অর্ডার দাও। Appeal is but by limitation, appellant is directed to take necessary steps. Appeal shall appear along with CRS ones.
I'm grateful.
Next,
And for the applicant. So there was a delay of 33 days, my lord.
your file grant?
Yes.
Yes, who is appearing for a state? Copy of the application is served upon public prosecutor. So and so, having considered the aberrations in the application, delaying upon the office of the Deputy Solicitor General, huh? In the office of the Deputy Solicitor General, matter will appear on Monday.
As your first.
Yes, next matter.
Lordship, I am from petitioner, praying for withdrawal this application, your lordship.
Not placed, dismissed.
No, grateful.
26 withdrawal হয়ে গেল। Not this. Next. Twenty-seven. Dismiss for default. 28 এর পরে একটু উঠবো।
My lord asked for the report.
Whether the person is same or not.
Report is placed on record. So and so and so and so are one and same person. Accordingly, liberty is given to amend the cause title of the petition and describe the petitioner as so and so alias so and so. Please give the alias name, right? Other matters after 5 minutes.
The other side.
Copies be served?
No, not yet.
Huh.
May I be
Copies be
permitted?
served upon the respondents, affidavit service file. Place the matter before the next available circuit.
Grateful.
Or next week we can keep it. What do you,
Next circuit.
next circuit?
We'll let-
Delay in compassionate amendment. All right, next available.
Grateful.
Next. Thirty. Is barred by limitation? Nobody appears. Adjourn this week. This week कर देते हैं सर. So and so appears for respondents, nobody appears for appellant, adjourn this week. Monday we are keeping. 32,
Lords, I am.
yes.
Lords, before I take my lordship, the facts of the case, my lords,
Yes.
and the relevant documents. Lords, in a nutshell, I will explain my lordship as to what the case is all about. Effect according.
Yes. What was the penalty imposed on you?
Dismissal from service. In a nutshell, my lords, if my
Your
lords
mental-
permits, my lords, I
Your
can state the
mental
facts.
state is quite turbulent.
I will come to that, my lords. First of all, my lords,
Your
the incident.
charge number 2 is not that grave.
In fact,
But
not
charge
my
number one
contention
is quite
is
serious.
something else, my lords. Herein, what happened was, I joined the SSB Sashastra Seema Bal in 2012, my lords. I had 6 years of unblemished track record, no blame against me. On the fateful day, that is on 13th of July 2018, my lords, I was performing the sentry duty at RP gate number 2. Now, my duty hours, my lords, started from 6 in the morning and it was to end at 9 in the morning. At around 8:45 or so, at the fag end of my duty hours, the allegation, my lords, is that I was scrolling my mobile phone. Now, there are different versions, my lord. One of the friends says that it was because my wife was pregnant and I had to give her a call. That was the reason. There is another version that comes out which says that because I wanted to inform the other person who has to take over the duty, that is why the mobile phone was being scrolled. But there is no denial of the fact, my lord, that the mobile phone was being scrolled. The duty officer, my lord, he approached the venue at the RP Sentry gate number 2. Now, he snatched the mobile phone from me. Now, during that process, my lord, what happened was I cocked the rifle. Now, cocking of the rifle, my lord, is a process wherein I pull the barrel back so that a live bullet from the cartridge is go to the barrel. That is the process, my lord. That is the allegation against me. There is no denial.
We have told you this conduct appears to be a bit
My lords,
dangerous.
I am not on the gravity of the offense, my lords. I cannot plead that before
All
here.
right, then.
My lordship, I am before a, I
Under
am
the
before a court of,
procedural,
yes, my lords. I am before the court of judicial review, my lords, and I need to show that there is a deficiency in the decision-making process that has happened with me. And that is what my case is all about, my lord. If I can have my lordship for a moment, my lords, there are two paper books. One is a paper book wherein all the pleadings are there, and another one is the act and the relevant rules are there. In the first paper book, my lord, if I can have my lordship for a moment on page 26. This, my lords, happens to be the convening order. And I will show, my lords, there are 7 different irregularities that has happened in my case, my lords. The offense may be grave, but then, my lords, the law has to be followed. That precisely is what my case, my lords. I cannot be bowled out on a no ball. They have to follow the rule of law.
we have followed it.
This, my lords, is the convening order at page 26. As per provision 172, my lords, I was performing the duty and there is a COI that has to happen. Now, my lords, COI is a court of inquiry procedure. The court of inquiry happens against me, my lords. The first time I was charged with, my lordship, before that, my lords, the court of inquiry proceeding, it starts at 30. I will not take my lordship to each and every question and answer. My lords, page 32 is of some importance. This is my duty officer who is giving a deposition. The person who apprehended me. And a couple of questions, I will not bother my lords with facts much. At question number 7, my lords, the question put to me at page 32 is, what was he exactly doing on his mobile phone? And the duty officer says, in my opinion, he was browsing internet as it was not WhatsApp, Facebook, or calling, etc. On the next page, question number 9, on being interrupted, what was his reaction? He recited that nothing, sir. Question 11, what was his physical reaction? It seemed normal to me. Question 19, what you observed in the sentry post? I saw that the rifle was held in the sentry's hand. Question 20, what was the direction of the barrel when you first observed it after being cocked? And the answer, my lord, says the rifle was held by the sentry in both hands at 45-degree angle pointing upwards. Was the finger on the trigger? No. What was the position of both hands of the sentry? The sentry left hand was on the upper hand guard of the rifle and right hand was on the small of the butt. Was the sentry holding the rifle with the barrel pointing towards his body anytime? No. So there was no intention of committing any suicide or anything like that. No. Was the sentry holding the rifle with the barrel pointing towards his body anytime? No. Was the sentry holding the barrel pointing towards anybody anytime? No. What was the facial and physical expression of the sentry at the time? He seemed normal to me. Did he have anything like fear or anger expression on face, stammering voice, trembling body, etc.? Nothing like this noticed by me, but he seemed a little bit scared. That is the direct deposition of the duty officer. Now let's at page 35, which would be the final takeaway from the deposition of the duty officer. Question number 43, my lords, at page 35. Did you notice anything abnormal behavior in the sentry CTGD Rajiv Kumar Hembram that day? He seemed normal to me. That is the deposition of the duty officer, who, my lords, happens to be also the apprehending officer. Now, at page 44, my lords, when my deposition happens.
Yes.
Question number 2, why and for whom did you cock the rifle? I have no exact idea, as many negative thoughts passed through my mind that since I have committed a mistake and that will attract severe punishment, whereas neither I have ever been charged earlier for anything, nor I had done any mistake ever. A notion strike my mind that my service may be done. Page 44, my lords, I'm so sorry, 44. I am at question number 2, my lords.
Please.
Then why and for whom did you cock the rifle? I have no exact idea, as many negative thoughts passed over my mind, and since I have committed a mistake and that will attract severe punishment, whereas neither I have ever been charged earlier for anything, nor I had done any mistake ever. A notion strike my mind that my service may be terminated, etc. My wife was about to call me over mobile phone after 900 hours, and she will find my mobile phone switched off, and I got worried. Thoughts of this effect prevailed in my mind, and without thinking, I cocked the rifle without any intent. Question 3, how did you assume that your service will be terminated? Because I has committed mistake of carrying mobile phone in the sentry post despite that standing instruction. are there that nobody will keep mobile phone while being on duty, and also same was intercepted by the duty SO and the action was to be effected over it. Have you ever come across that someone has been dismissed on minor grounds of keeping mobile phone on being duty? And the answer, my lords, there too is no. Now, my lords, I was charged. And I was charged, my lords, will find at page 33.
No, but
No, I have to correct.
Mr.
The
Mishra,
first charge sheet is page 57.
Mr. Mishra,
My lordship.
his state of mind is also reflected. If you see page 34, question number 27.
34 at 27, my lords. Did you ask him specific reason for rifle cock? He said that he has a domestic problem and due to which he will commit suicide. My lords, this may be there, my lords. There are a couple of things, my lords, I cannot improve upon. The facts that are there are there.
No, I'm just
So,
pointing it out.
my lordship. And my lords, I also know that I will not win the case by showing that there has been a deficiency in the decision itself. I need to show that there is a deficiency in the decision-making process. And that is what, my lords, I am up to. If I can have, my lords, for a moment, my lords, on page 57, that is the first charge sheet that has been issued against me. And I will explain, my lords, as to what is the first and why there is a second charge sheet also. Page 57, my lord. Only one charge. 5757, my lords. And I has been charged with section 22. Section 22, my lords, is applicable when there is a striking or threatening act upon a senior officer or a superior officer that is there. Section 22, my lords, page 57. And then there is a gist of allegation that is also there along with the charge. Then, my lords, what happens is that there is a ROE that happens. The ROE's order is at page 60. 61 again is the charge sheet, my lords. I will not bother my lordship with that. The ROE gets completed at page 85. ROE, my lords, is the recording of evidence that happens. The ROE proceeding at page 85, my lords, was submitted before my immediate disciplinary authority, who happens to be the commandant. He is my immediate disciplinary authority and he is my controlling authority as well. Page 85, my lords, the ROE order gets submitted along with all the reports. Page 88, my lords, is the punishment that is awarded to me. 8888, my lords. Charged with only one section, my lords. I have shown that to my lordship, section 22. And this is the final result from the Summary Forces Court, the SFC court, page 88. And the punishment, my lords, will find is at Roman small I. I was punished with imprisonment in forced custody for 40 days. Starting from, my lords, 11th of February 2019. That is the date of the punishment. Now, my lords, two things.
This was proposed by the ROE.
This was proposed by the SFC. There are three different types of courts in all the CAPF Act. This is a CAPF Act. One is a petty summary court. It's a PFC. Then there is a summary forces court, 3 judges. And then there is a general forces court, 5 judges. In my case, lords, it was a SFC. It was a summary forces court. So the summary forces court, lords, awarded me a punishment of 40 days of imprisonment. Now, how this award was to be carried, my lord? If I can have my lordship for a moment on the Act first. Chapter 10 of the Act, not I would be referring to page 31. The Act are first, my lords, and then it is followed by the rules. And the page numbering, my lords, are at the top right-hand corner. Page 31, my lords. Or my lords, we will look into section 22 first. The section that I was charged with. So that everything is in synergy, my lords. At page 8, my lords, will find the section 20. As per section 22, my lords, the punishment that 1, Roman 1, the punishment that could have been awarded to me was up to 14 years. But the summary forces court was of the opinion, my lords, that I should be given a 40 days of imprisonment. And then there is other mechanism also. If this punishment is not sufficient, there is provision for alternate punishment also. That also I will take to my lordship. But good, bad or ugly, I was awarded, my lords, with 40 days of imprisonment, which I suffered, starting from 11th of February 2019. And how this punishment was to be suffered, my lords? Section 135. How the sentence has to be carried out in case of an imprisonment. Section 135 deals with it. In fact, chapter 10, my lords, the entire chapter is important. But I will be bothering my lords only with section 135. And that, to my lords, only with subsection 3 of 135. So in case if the imprisonment is less than 3 months or 90 days and passed under this act by a force court, the appropriate officer under subsection 1 may direct that the sentence may be carried out by confinement in court's custody. So what was done to me, my lords? For 40 days, starting from 11th of February 2019, I was put under confinement. My liberty was curtailed. I suffered that punishment. 40-day imprisonment, it was given to me. I suffered that punishment. Thereafter, my lords, what happens? After exactly, my lords, 113 for a moment, my lords. After exactly 1 year and 5 days of suffering the punishment, 1 year and 5 days of suffering the punishment and being into active duty, page 113 comes up. Page 113, my lord, says, this is signed by the DIG, and it says that the commandant 41st Battalion may refer letter number such and such regarding somebody force court proceeding on disciplinary case in respect of UIN such and such, the petitioner hearing. Whereas, on the basis of the evidence on record, the undersigned finds that the disciplinary authority has not appreciated the facts in totality. And whereas, accordingly, the punishment awarded is found to be not commensurate with the gravity of the offense and evidence on record. And whereas such approach or part of disciplinary authority may compromise with the discipline and conduct of the force and may lead to some unwarranted incident in future. Such cases where force personnel have exhibited their conduct in casually handling the weapon cannot be dealt with leniently, as it will set a bad precedent. Accordingly, in terms of section 132 of the SSB Act, the summary force proceeding is annulled. Now, 3 things, Millers. First is, this order has been passed after 1 year and 5 days of my already suffering the punishment. The punishment has been suffered. It didn't happen during the currency of the first sentence. Had it been during the currency of the first sentence, not still it would have been understood. Page 113, Millers. I'm so sorry. I will read that again, Millers. Page 113 is an order that is passed after 1 year and 5 days of my suffering the imprisonment.
Your order was passed on
my order was passed on 11th of February 2019.
page 88.
Page 88.
Right.
The punishment gets over.
Right. The order is under 112, right?
The 113 minutes is the new order, and my punishment order is at page 88. No, that minutes is the act. Oh, I'm so sorry.
So the duty is to send it to the confirming officer.
Confirming
The
officer.
presiding officer sends the records to the confirming officer in terms of
No,
111 subsection 2.
There is a difference. There, my lords, is a difference. If I can have my lordship, and that is exactly what I was trying to point out. If I can have my lordship on the act, page 29, my lords, it deals with confirmation and revision of proceeding.
First come to 111 subsection 2.
111 subsection 2, lords. My lordship. Confirming officer or to the authority empowered to deal with the finding as the case may
Please
be.
read it.
My lordship. 111 2, my lord says the presiding officer of the court So what happens, my lord, the presiding officer of the court is the officer from the SSB. He sends it to the confirming officer, who in my case is my controlling authority, the commandant. So the section says, the presiding officer of the court, or in case of a summary forces court, the officer holding the trial, shall forthwith report the case to the confirming officer. So it was sent to my commandant, and it was immediately carried out.
Where is it carried out? Where is the confirmation of this order? Page 88 is a finding of the presiding officer.
My lordship, my lordship.
Now that has to be confirmed by your commandant under 111(2). Then only it becomes final and binding. And that will be under 129.
No, my lords. My confirming officer is my commandant. And the relevant section thereof is 52. No?
Page 88 is an order passed by the presiding officer.
My lordship.
That must be forwarded under 111(2) to your commandant.
Commandant.
Correct?
Commandant.
Where is the commandant confirming the order of the presiding officer? Till the commandant confirms, the order is not binding.
My lords, page 90.
Submission.
91, my lords, the verdict of the court was promulgated to the accused on such and such. The trial was completed. The original proceeding of the court is forwarded for your necessary action.
Yes. Yes. This is being sent to whom? The judge advocate.
My lordship.
Then
My lords, page 97. Page 98, my lords, that my commandant says, page 98. Taking all this matter into consideration, I now sentence the accused such and such to undergo 40-day imprisonment. So it has been confirmed by the commandant. Now, my lords, I would again, my lords, take my lordship to
one second.
one. Page 113. Because, my lords, that is where the illegality starts. The one that I was referring to, my lords. Now, herein, there are three takeaways, my lords, at page 113. The first, my lords, is that the punishment was already over after 1 year and 5 days of the punishment having been awarded and suffered.
113 of what?
113 of the booklet, my lords, the pleadings, my lord.
113.
That was the order impugned, my lord, the first order that I was into.
This is under what provision of law?
Yes, this is under 132. Now, if I can have my lordship for the moment of 132. And that is where things becomes interesting. In fact, my lords, I would like my lordship to refer to chapter 9 in totality. Chapter 9, my lord, deals with confirmation and revision of proceeding. What will happen once the summary forces court proceedings are over? And then, my lord, section 128 to start with.
One by one you come.
My lordship.
Your case is 121 first.
121.
According to what is 121?
No finding or sentence of general forces court or petty forces court shall be valid except it has been confirmed. So in case of...
So your most important page is your commandant.
113. That is where it starts.
Oh my God.
I'm sorry. My bad.
When was it confirmed?
Oh. Lord, it does not require confirmation, but I referred my lordship to page.
It does not require confirmation.
No, my lord. As per 128, it does not require. That is what I was referring my lords to. There are three types of court, my lords.
No,
if
all
I may
right,
say
all
it this
right,
way.
all right.
One is a GFC, one is
Correct. SFC
does not require
does not require confirmation.
as per 128.
So according to you, SFC order, as soon as it is pronounced,
Promulgated.
is to be promulgated. Be that as it may, it got confirmed, and by 121, it is confirmed and should be considered to be final and
to
binding.
final.
Now,
But before that, my lords, in 128, the word used is the finding and sentence of the summary portion court shall not be required to be confirmed. The word used is shall. So it is mandatory in nature.
I will completely agree, because 121 does not govern a summary procedure code.
Yes,
It governs GFC and
to the exclusion of
PFC.
SSC. To the exclusion of
PFC,
my lordship,
GFC,
my lordship,
121,
my lordship,
128, SFC.
my lordship.
Very.
Now second thing, page 113, my lords, the DIG is using the power under section 132.
Once.
The second last penultimate paragraph, my lords.
Now come to 129.
129.
Please, 120.
129. Oh, 129 is in my favor.
Correct. We have never said anything is in your
Because-
favor or against you.
There are only two things that can happen.
Mr.
And both
Mishra,
are in favor of the accused.
we are neither with
No,
you
Milord.
nor against you. We are just
I am.
learning the law from you
My lordship, my lordship.
and exploring the provisions.
My lordship, I am on 129.
Correct. Now let's see 120.
129. The proceeding of every summary forces court shall be forwarded without delay to the officer not below the rank of the ADIG, within whose command the trial was held, or to the prescribed officer, and such officer or the Director General or any officer empowered over him on his behalf may, for reason based on the merits of the case, but not on merely technical ground. There are two consequences. One is set aside the proceeding. That is one thing that he can do. And the second is reduce the sentence. So there are only two options that is available. But this section, my lords, was not utilized. What in fact was utilized by the DIG, my lords, and that is clear from the penultimate paragraph at page 113, was he applied section 132, which couldn't have been done. Because in 132, my lords, the power vests only with the Director General or a prescribed officer. He was neither the Director General nor the prescribed officer.
Correct.
So he couldn't have utilized section 132 and annul the proceedings.
Right.
Now, if I am the commandant and if the DIG is writing me this letter, what do I do? What the commandant does is, at page 114, the next page, my lords, he writes it for a legal opinion to the JAG. The next page. Because he is in a state of dilemma. He doesn't know what needs to be done now. The person has already underwent the sentence. So what to do? In 114, my lords, he writes it to the JAG for legal opinion. JAG, my lords, is a branch which deals with all judicial and legal cases and everything, my lords, and also gives opinion. Paragraph 2, last line is important, my lords. Accordingly, he was kept in forced custody with effect from 11th February 2019 at 1400 hours to 23rd 3 2019 at 11:30 hours. So I have already underwent the punishment. Then at page 113, last line, he says to the JAG, in this regard, a legal opinion may kindly be solicited that what course of action may be taken now, because the incumbent has already suffered the punishment. What to do? Now comes before my lordship the third illegality. The JAG replies at page 116. Now the JAG, my lords, would have said two things. Either the JAG would have said that no, he has already suffered the punishment, nothing more requires to be done. Or the JAG should have said that no, as per rule 54 of the SSB rules, you are the commanding officer, you are the controlling authority, you are the disciplinary authority, you need to take an opinion without any other external interference as to what needs to be done. The JAG does neither. What the JAG does is, he says battalion to take action as per direction of DIG and must complete proceeding. And thereafter, my lords, everything was fait accompli, written on the wall. What happens? Page 117. Because the commandant is left with no option. And why this is a violation of rule 54, my lords, I will come to that. But before that, page 117. The commandant, my lord, says that the period of last line, my lord. Page 117, last line. the period of punishment will be treated as duty for all purposes. My liberty was curtailed for 40 days, and he says that it will be treated as in duty. Punishment already suffered. Then the second charge sheet comes into picture, page 118. This time, for the same offense, for the same incident, I am charged with two different sections. One, my lords, is section 44C, and the second one, my lords, is section 43.
44C and
43, which are graver in nature. Which I will come, my lords, to section 44C and 43.
They are not the same offenses, are they?
Same offenses, no, my lords, but from the same incident. And that is another violation. Because the act says that all offenses out of the same incident has to be brought together and tried together.
Enabling provision. Enabling provision, Mr. Mishra.
But my lords, in case
If by mistake a graver charge has been omitted, that's an enabling provision. It does not take away jurisdiction to try you on that charge.
my lordship, this time, my lords, I am charged with 44C and with 43. And then thereafter, my lords, second order is passed. And the second order, my lords, will find is at page 121.
One is good discipline and another attempt to commit suicide.
Miscellaneous offenses.
They are completely independent of the charge that was leveled against.
But
you.
just one more thing, Lord, if I can have my lordship for a
So
moment.
all your endeavor to say that it was a case of double jeopardy.
No, I'm not on double
no
jeopardy.
finding.
I'm not on double jeopardy, Lord. Just one more thing, Lord. If I can have my lordship for a moment on rule 54 of the SSB rules. This is at page 28 of 110, Lords. What is the commandant supposed to do when a proceeding of COI and ROE is placed before the commandant, who is my immediate controlling officer and the disciplinary authority?
Rule?
Rule 5454, Lords, at page 28 of 110. Where an officer has been detailed to prepare the record of evidence or to make an abstract whereof he shall forward the same to the commanding officer. The commanding officer may, after going through the record or abstract of evidence prepared by him or by any other officer, there are 6 things that he can do. One is remand the case for recording additional evidence if required. Dismiss the charge provided that where disciplinary action has been initiated against an officer or a reference from a superior authority. Rehear the charge and award one of the summary or minor punishment. Try the accused summarily under section 56. Remand the case. Apply to the competent authority or authority to convene the court. So herein, the takeaway from Millard's rule 54 is that there are 3 things that needs to happen. One is there has to be an application of mind that the commanding officer has to do. Second, Millard says there has to be a framing of opinion. And based upon such framing of opinion, the action has to be taken. It nowhere says that a third party interference or a third party opinion is required. That too from an authority which is my revisional authority. This is acting under dictation. If I can, Millard, I have just referred to one judgment, Millard.
There is no dictation here. It is a statutory power of the authority to take a decision. Until and unless you can challenge 14th February 2020 as something which is inherently perverse, we do not find there was a lack of jurisdiction of the superior officer in taking a decision with regard to the necessity of a fresh SFC on different and distinct charges. That is clearly within the power of the superior.
But when the punishment has already been suffered.
Yes, yes, let us say there is a question of 2 or 3 acts of misdemeanor and punishment is served out because of one misdemeanor. It does not stand. We have clearly made it. Don't make out a case of double jeopardy.
No, no,
No, then
I am not double jeopardy.
Mr.
My
Mishra,
lord, my lord.
the crux of submission, the words you are using may be different, but its legal import is nothing but double jeopardy.
Lord, section 87 for a moment, Lord. And I will rest my case, Lord.
Whatever you already rested.
Section
Now you
87 for a
can-
moment, for my satisfaction, Lord. Section 87,
Go on, you go on. We have followed. There is nothing here.
section 87 for a moment.
Uh,
There is a prohibition of a second trial.
correct, on the same charge. On the same charge, Mr. Mishra. Nothing more. Yes, Mr. Mojumdar.
My lord says also says on the same facts.
Correct. We have understood.
My lord.
The words facts have to be read with the charge.
Lordship, without taking much time, my lord, his lordship in the single bench. During the disposal of the writ, we had filed a little short note. My lord, I think that should be in the record. If not, I will supply it to your lordship.
We'll keep it on another day. Monday we keep it?
Lordship,
Monday we keep it? Please bring out and flag the note. for us.
lordship.
Mr. Chaudhary, you were?
Well, next, but not in this.
Oh, not in. Good. Thank you, Mr. Mishra.
My lord. I will try to convince a little bit more on Monday to.
All right, all right.
If I can take up some other point.
Any other point? Because
That liberty may be given.
we are with you if the same charge was.
I understand.
If it is not the same charge, just consider a situation where only the mobile phone presence was charged and you were censured. The central authority or the superior officer, director general or the prescribed person says, no, he had also cocked the rifle, so this should be annulled. And on that recommendation, the charge of cocking the rifle comes. Mr. Mojumdar, what is going through our mind is, there can be a different charge. We understand 43. We understand 43. But attempt to commit suicide. Where is the material for attempt to commit suicide?
We will be, right now, lordship, a statement made by the delinquent himself.
Please,
Lordship, I will
place it
mark it.
before us.
I'll mark it.
Because what we felt was, you see, what Mr. is arguing is this. The first charge was using a mobile phone, good office, etc. Point taken. That was not at all charged that if the mobile phone is being used, it comes within a category which is 43.
Lordship.
That charge was not at all framed. So the authority definitely, as a supervisory authority, had power to indicate, SFC commandant, please look into this. I am setting aside, I'm annulling the proceeding because you have not applied your mind to the relevant provision. But another charge was framed that he had cocked his rifle to threaten your superior. Is not that charge and the subsequent charge of the 46C patently inconsistent with one another? One is threatening the officer, another is trying to commit suicide.
I got your lordship's sponsor. I will.
That area we need a clarification. We're not really impressed by Mr. Mishra's submission that the initial proceeding ending in a finding against him for 40 days of imprisonment in forced custody
Lordship.
would exclude jurisdiction to apply mind and find out whether there were aberrations which constituted offenses under other provisions of the Act. That is independent of the charge. But if the indication to initiate the subsequent proceeding runs completely counter to the earlier charge on which he is found guilty, what will be its impact? Although we feel the setting aside means that the finding of guilt is also effaced and thereby. So
No, sir, I have a case. Because in his deposition, he says that he never intended to commit a suicide.
we
My lordship,
we
on
will
Monday.
we will address the issue on perversity too.
My lordship.
On perversity on 46C. 43, I don't think you don't have much of a case, but for 46C, whether he attempted to commit suicide, what is the material?
Malus.
We cannot go into a reappreciation.
No.
If the finding is patently perverse and there is no material which an ordinary man, we will use the principles of Wednesbury. And if on the Wednesbury principle you survive, you survive.
I will try on
All right.
Monday.
I think that
And
is
if you-
something you would like.
Take care of that.
It's a dismissal, Mr. Mojumdar.
No, my lord,
Dismissal of
my lord, I was, Mr. Singhania dictated me a different thing, so I smiled. Mr. Singhania was hoping that your lordship would pass one line order.
We will definitely. Nobody know Mr. Singhania's.
He always predicts the future correctly.
Expectations will never be belied. Heard Mr. Mishra? Mr. Mishra for the appellant.
He feels my pain.
Mr. Mojumdar begins his submission. Mr. Mojumdar, Mr. Singhania commences submission and prays for further time to refer to the written notes submitted before the Honorable Single Bench. Matter is fixed on Monday.
Malus.
Thank you.
Mental state.
Yes, next matter. Nobody, yes. Yes, what do you say?
33 मतलब kindly fixed it Monday on behalf of Mr. Shaktipada Jana.
Not this.
So there is a delay even, my lord. So for a
Item
very
number
short period.
34 minute of appealing for the appellant.
But I shall condone. There is a direction from the from the previous honorable bench. A report has been called for that the impression was given that commissioner of police acted upon on the basis of order of the honorable single bench, which I have filed a report, which is kept with the.
First to delays we can.
Exactly, my lord. That only I have pointed out in the last occasion.
My delay application
So there is
is
a
can one Milord.
which is showing in the Milord, the cause is the defect. I do not know what is the
Mr.
defect.
Chatterjee,
My lord.
delay has to be condoned.
Yes, Lord. Delay has to be condoned, Milord.
So on consent of parties, we condone the delay.
Otherwise,
Delay condone can dispose of, right?
so there is no defect there.
No.
Can one is a section 5. Can 3 is an appropriate order, can 2 is a stay application.
All right, the report of the Commissioner of Police,
Amalad, I have 5.
you have filed.
Kindly, particularly kindly see the annexes.
Milord, I tell your lordship, Milord, yesterday my lord was hearing an anticipatory bail. Milord, item number 27. Milord, this is arising out of the same incident.
Right.
Milord, this is this matter appeal. Milord, arrange the order where Milord, the honorable single judge directed Milord the police to take steps and inquire into the incident. Now, I am aggrieved by the portion of the order where Milord is in complete contradiction of the Milord coordinate division bench, which Milord says Milord the petitioner has to right of carrying on the business on the fruit line. Now, Milord, what happened, Milord? Yesterday, Milord, I heard the Milord what fell from my Lord. We are taking a clue from that. Milord, the private respondents has interfered with the possession of Milord the police. Milord, the seized articles, the tankers, if my Lord recalls, Milord are missing due to Milord the possession taken by the private respondents here.
But Commissioner of Police did not register any FIR.
Yeah.
No, we have to file because Commissioner of Police did
You
not.
filed
We
the FIR, na? Complainant filed the
yes,
FIR.
yes.
What we
Yes.
have said is the removal is of an old tank. It is the depreciation, etc. value is not that high, so custodial interrogation is not necessary. Let the investigation go on.
Yes, let the investigation go.
Ah.
But I
But
only
here
say that
the-
this.
Malan, the appeal challenge is that he has, though he has made a party, he has not been, a representation was not been made. That was a challenge by an appeal, by the appellate Malan hearing. That was the only scope.
No, there are two things.
Can you point out the division bench order once?
Where is the division bench order? What is the
Milord kindly takes up my can 2, Milord. Can 2, Milord, page 34. Milord, this arises out of a writ petition filed by the private respondent Nirmal Kumar Ghosh. Milord, wherein he referred to the Milord in the petition that the oil tankers were present, and Milord, he has also Milord directed ISCL to remove it.
And to
Can 2, Milord. And Milord, suppressing this division bench's order, Milord, the present impugned order was passed. Can 2, Milord.
Last page of the order.
Can to page
Page 34, Milord. Milord, the operating portion, Milord, last page 37, Milord sees. May I just place it, Milord?
So this was a different writ petition.
Yes, my lord, in this writ petition,
Filed by Moina, nothing to do with Nirmal. Unless there is some.
no, my lord,
that has
it's
to
a
be made.
petrol pump. My lord, it's a petrol pump
Nothing
which
to do
was,
with a petrol pump here. We'll address that.
Yeah.
We are the writ petitioners there. Lost representative, this representative. And this order is under review before the principal bench.
my lord, in this writ petition, my lord, Nirmal Kumar Ghosh was also, my lord, a party. So he was aware of this, and my lord, this division bench orders, my lord, has been carried up to Supreme Court and it has been dismissed by the Honorable Supreme Court.
Developed is an inter-party dispute between Moina Gop and this gentleman now. There's nothing to do with the involved. We'll have to distinguish the two. The two separate portions. And these orders have been shown just when like lost replacement.
Was there a division of the property by meets and mounts?
Yes, ma'am.
Yes, my lord, may I tell your lordship, my
Then
lord,
by
what
the writ
happened?
petition has been not been annexed.
My lord, there was a petrol pump run by me, my lord, and they were the, my lord, co-owners. Now, my lord, they filed a partition suit inter se between themselves.
Yeah, Mr. Chatterjee, just
Yes.
let us recount whatever we recollect from the anticipatory bill application. They had purchased it from one
Yes. Yes, my lord.
erstwhile owner.
Erstwhile
You
owner.
were the lessee under the erstwhile owner.
Erstwhile owner.
In
Yes.
84, they had purchased the property.
Yes.
In 2001, the retail
I
outlet
was,
closed
yes,
because
yes.
of a criminal case for adulteration.
Yes,
Thereafter, a partition suit was filed between the brother and the sister, and the
yes,
partition suit has been decreed. The
yes.
sister had entered into an agreement for purchase from
Sale.
your client, and that
Yes.
is the subject matter of the agreement for sale, that the sale deed would be executed after the disposal of the civil suit. Which is the civil
Yes.
suit? Which is the civil suit that is referred to?
Now, my lord, yes, my lord, what happened, my lord? This civil suit which the Honorable Division Bench says, my lord, this civil suit has, my lord, only a direction, whatever you want to get it from civil court. Now, my lord, inter se
We
Moina
have
Gop
asked,
and
please, we have asked you as per the agreement between you and
my lord,
the.
that's in an arbitration proceeding, not civil suit. My lord, there was an arbitration clause as per my instruction. Arbitration proceeding has been carried out.
You are jumping one step ahead. Arbitration clause is in the sale agreement,
Yes.
but the terms of the sale agreement refer to a civil suit.
That is the partition.
That is the partition.
Partition suit. That's a partition.
All right, all right, all right. So that is the thing we want to know. So within 3 years, it is to be executed. Whether it is executed or not, it is a matter of a civil case.
Civil.
In the meantime, a dispute crops up between your client and the appellant's and the respondent writ petitioner's sister with regard to parking of vehicles.
Yes,
And
my
the
lord,
division bench says, since there is a terms of agreement for purchase, any dispute relating to the property go to the civil court.
Yes.
Now the writ petitioner alleges that after the partition and the property being divided into meets and bounds, in the purported name of removing underground tanks, you had broken the wall, the
yes.
boundary wall. Honorable Single Judge takes note of these allegations and say that let the Commissioner of Police look into this issue, and after, if it is found that certain aspects
From delinquency are there, then
the FIR will be registered.
the private party
Yeah.
as well as any police.
Till date, Commissioner of Police has not registered any FIR. We have not seen the report of the Commissioner of Police.
Now, my
And
lord, only one thing, my lord, in the impugned order, my lord, there is a recording that there was no direction to break open the boundary walls. My lord, here, my lord, is in direct
please, sir,
contradiction.
let us come to the impugned order.
Yes.
Please come to the impugned order does not make any conclusive finding.
My lord, my lord, just my lord, second Milord, second page of the impugned order.
Yes, let us see.
Milord, the second paragraph, I have taken into account the submission of learned advocate appearing for the petitioner as also the state, and on an appreciation of the same, I find there was no direction for removal of the wall under the garb of removal of tank. The demolition of, if any, of the wall has been extended. Now, well, this portion.
Now come to the,
Milord,
all right, that has to be read with the last paragraphs, if the conditions are satisfied. And
Yes.
if there is no court order for demolition of the structure that has been submitted and
Yes.
initially instructed to the learned advocate, I direct the Commissioner of Police. So
Yes.
his lordship is not coming to any conclusive finding.
No, his lordship
We'll
is not
clarify
coming
that.
to court.
We'll
Milord, only
clarify
thing
that.
Yes. Milord, one more thing, Milord. Milord, since Milord, now it is apparent that the private respondents have interfered with the custody of police as the alarms vis-a-vis the petrol pump. And Milord, today it is apparent on record that after acquittal, Milord, the seized petrol pump should be handed over to me because there is no Milord eviction against me. Milord, partition may happen between the parties, but that doesn't give right to the Milord.
All these
the
things
co-
cannot be decided in this case. File a civil suit if you
Milord,
file.
in the BNS, Milord, in the BNS, Milord, there is a provision, Milord, which says, or the Milord, criminal procedure, Bharatiya Nagarik Sukha Sanstita 502, may I just read it? When a person is convicted of an offense by use of criminal force or show of force or by criminal intimidation.
What is
And it appears-
convicted, Mr. Kushal Chatterjee?
Yes.
After conviction, you come up.
Now, Milord,
That provision was
Milord,
already there in the Code of Criminal Procedure,
yes,
as in 452 of the Code of Criminal Procedure.
yes,
So this is
yes.
a post-conviction exercise of trespass. You will be handed over lawful
No,
possession.
Milord, I
First,
am before.
you have already started a criminal case. Post-conviction, you come up for recovery. Or
Milord, only
if you feel there is an illegal dispossession, file appropriate civil proceedings.
Milord, otherwise, the division bench order goes to a
Mr.
toss.
Chatterjee, this appeal is not against your rights. It is with regard to the order passed by the single judge on the writ petitioner's writ petition.
Milord, I was a party, I was not even heard. I was not even
We are
served.
hearing you. We are hearing you. We are hearing you.
Yes.
And we find
Milord,
that the order does not prejudice you at all. Order in appeal. Because the finding that you record, we see, is hedged by further observations that these inquiry of the Commissioner of Police would also go into the question whether there was a order passed by the civil court for appropriate court for demolition, and if the underground tanks were in fact below the wall which has been demolished. So if these findings are made, no FIR will be recorded. If the FIR is recorded, they must precede the findings in terms of the court. Let us see what Mr. Chaudhury's client has done. Has the report? We don't want order impugned. We want your report. Where is the report? Where is the report? Commissioner report?
Can I hand it over?
Have you got
There is the
status report? Right.
kindly come to the inquiry report, that is Annex A.
So he says there is no demolition of wall at all.
But there is a demolition. There is a demolition. But the moment it has been demolished, Milord, for lifting the tank, the police officers say not to raise or not to lift the tank. We should be supported, Milord.
Please come to paragraph 2 of your report.
Milord, 2. Yes.
Whether the conduct of the investigator are correct or in consonance with
Yes.
the
Appears that the IC Pradhan intended to comply with the direction of the learned judicial magistrate Siliguri to hand over the seized articles to Narayan Prasad Lohia. Accordingly, Sergeant Sir GD was endorsed, visited the spot along with the officers and force was deployed, maintained law and order. On 1st July 2024, the Narayan Prasad Lohia engaged laborers with equipment excavate the soil to take out the well tankers from under the ground. And during the excavation, it was found that there was a brick wall standing over one of the well tank, as a result of which the said wall was partially damaged. Due to the said wall, the process of excavation was stopped, and the conduct of the police personnel was in confidence with the order passed by the landed court. That was in the improved order, first paragraph. Then there was another query, whether it is any demolition of the structure of the property. Then observation, there was no demolition of any structure, but a part of the brick wall was damaged and broken around 1.5 meters due to such excavation process. Next, we have 3, observation of the Lord the Honorable Single Bench. In case there is a demolition in the structure of the boundary wall.
All right, we have followed. There's nothing, Mr. Chatterjee. This is nothing. The report of the Commissioner of Police exonerates your client.
Yes, but that's
An
why my lord,
exonerative report. So we'll
Being-
record that. We'll record that, and we will say that the Commissioner of Police has clarified this position in the course of inquiry, and separate complaints have been lodged by the party. One by the private respondent writ petitioner, respondent writ petitioner, alleging that you have unauthorized setup hoarding, and you have, with regard to illegal removal of the tanks, both the investigations shall be conducted independently and in accordance with.
That we are.
within a
All right.
specified time, if within a specified time.
About
if it can.
specified time.
Well, otherwise, my lord, I'm not able to run my business, my lord. But
That
I'll
is
be-
not, that is not our headache. Whether you have a legal right, restoration of lease rights is not restoration of license by IOC.
My lord, I have written to IOCL. IOCL says.
So I
remove the
let
encumbrances,
IOCL
you-
first give you license, then talk of business.
My lord, unless the encumbrances are removed, my lord.
Appellant respondent has assailed. तो क्या करेगा उसको? ये तो repossession लेने का चक्कर चल रहा है.
Yes, exactly. And police is in between that. All someone is taking the credit, we become.
We know, we've seen it. Your report is clear. Appellant respondent has assailed judgment and order passed by the Honorable Single Judge, whereby the Honorable Judge directed Commissioner of Police to look into the complaint of the writ petitioner alleging unauthorized demolition of a boundary wall under the guise of handing over seized articles, handing over seized articles, that is underground oil tanks. 3 underground oil tanks. A brief factual sketch giving rise to the appeal is as follows. Writ petitioner and his sister, Moina Go, are the lessors of the property. Appellant, appellant is a lessee of the said property. Full stop.
May I say was a lessee because we have terminated the lease.
Was a lessee of the property. It is contended that the lease has expired through a flux of time.
But we have terminated by way of notice.
After a flux of time,
After
will not has since expired by has since been terminated. Was a lessee which has since been terminated. So colon there, semicolon. Appellant was running a retail petrol pump under the name and style of East India on the leasehold land. In 2001, on the allegation of selling adulterated oil, his license was terminated by IOCL. Semicolon, criminal case was registered against him and the pump was sealed. Full stop. In 2023, appellant was acquitted of the charge.
My lord, here, my lord, a correction, 2019 judgment was passed for acquittal.
আচ্ছা, in 2020 ওইখানে না ওই অর্ডারটা তাহলে 2019 we dictated that order, nobody corrected it. These are the problem, no assistance.
My lord, I've arranged those judgments. My lord.
Keep the data wrong. They don't see data wrong.
No, nobody sees. The only thing people see is whether we got the relief or did not get the relief. We generally dictate them on board, so we have the assistance. A senior advocate was there. There were two advocates here. Nobody indicated that the acquittal was in 19. They were more apprehensive that if the acquittal is said at 19, maybe the judges will have a different view. This is sad. In 2019.
And 2012, my lord, there were two cases, one acquittal in 2012.
We
and
are
second
concerned
acquittal-
about your adulteration of oil.
Well, 2019.
In 2019, they were acquitted. It is contended. Date diyo na, subsequently, the appellant was acquitted. After acquittal, appellant sought to renew his business. Sought to renew his business and obtain and take possession of the underground tanks in the property. In the meantime, the property had been partitioned between the appellant and his sister, Moina Go.
No, my lord, appellant is myself. My lord, the private respondent.
Between the writ petitioner and his sister, Moina Go. When the Moina Go writ petitioner, now in the writ petitioner alleged, now alleging that the appellant, with the aid of police personnel, trespassed onto the land, onto the property, and demolished the boundary wall. The writ petitioner approached this court for various directions. Honorable single judge obtained called for report from the state respondents. After perusing the reports,
There was no the report was called. by the honorable single judge.
files a report for the state. What?
PBS, not in petition.
Yes, in the writ petition, come to this. Oh, in Lohia's case it was.
These matter no input from my extraction.
All.
PBS report was.
Yes. Honorable single judge, after considering the contentions of the writ petitioner and the state respondents, inter alia held as follows. বলে না? এই পুরো set out I have taken into account থেকে with these observations disposed of. ঠিক আছে? Next paragraph. Mr. Chatterjee, challenging the aforesaid order, submits that his client had not been heard. Honorable Judge, without giving opportunity of hearing, Honorable Judge had come to a finding there was no direction for removal of wall by the judicial magistrate. Good stop. By the judicial magistrate. And under its garb and under the garb of removal of tank, the demolition has been made. Full stop. He also contains in a collateral proceeding taken out by the sister of the appellant, a coordinate bench had relegated the parties to agitate their claims before the civil court. Good stuff. Mr.
Naveen Bari.
Mr. Bari, for the writ petitioner content submits, the appellants had illegally demolished the partition wall, thereafter, they lodged false criminal cases, alleging that the underground tanks had been stolen by his clients.
That FIR was filed 6 months after. After this forceful possession, they had taken possession of half.
That is why we are saying thereafter.
There.
Had been stolen. Appellant has been granted pre-arrest bail in so and so.
Writ petition.
Writ petition.
Respondent number 7.
Writ petitioner, respond number 7. Additional Advocate General submits Commissioner of Police has made an inquiry and the report has been filed before the court, before this court. Having heard the learned counsels at the bar, we note, we are of the view, Mr. Chatterjee's submission that the Honorable Single Judge had made conclusive finding that his clients had demolished the boundary wall under the garb of removal of tank is misconceived. The said observation has to be read with the final direction given by the Honorable Single Judge that all the factual aspects, including the issue whether there was any court order for demolition of the structure, etc., were to be inquired by the Commissioner of Police. The order in appeal does not finally decide the issue to the prejudice of the appellant. Be that as it may, Commissioner of Police has already undertaken the inquiry, which had undertaken inquiry, and the report is placed before us. Relevant portion of the report is set out herein below. From the herein below. Set out our report. And set out herein below. Yes. No exception has been taken to the said findings, full stop, by either of the parties. a perusal of the findings by the commissioner of a perusal of the findings clearly show that the demolition of the structure demolition of the structure that demolition of a part of a brick wall was an inadvertent casualty when its excavation process was undertaken to recover
Carry out the order of the.
to recover the 3 underground tanks and hand over the said tanks to the appellant. In such to the appellant. Full stop. In such given this situation, it cannot be said that the excavation was not intrinsically connected with the discharge of official duty, that is recovery and handover of the seized items, that is underground tanks. Full stop. It is also relevant to note it is also relevant to note it is also relevant to note the excavations note that the underground tanks were found missing, and it is alleged that the writ petitioners had removed them. However, taking into consideration, however, the accusation was noted, however, in the criminal proceeding, noting the accusation to be based on mere suspicion, and as the owners of the said tanks, that is IOCL, had not lodged any complaint against the writ petitioner, this court was inclined to grant pre-arrest bail to them.
Yes, sir.
Investigation with regard to the theft of the underground tanks. Mr. Chaudhuri contends investigation with regard to recovery of the underground tanks are in progress.
Recovery, my lord. Regards to the allegation of
No,
the theft.
Sir, the recovered investigation with regard to theft
Yes.
of the underground tanks
Yes.
are in progress, and the tanks shall be restored to its lawful owner as soon as they are recovered.
Only one, the writ petitioners, we were only the writ petitioners. Moina Gopur is a different entity not appearing today.
We are coming to that. We have just talked about the writ petitioner. Full stop. We are also not in, we also place on record the fact that we also place on record the observations made by the coordinate bench in by the coordinate bench in
MAT 1399.
MAT 1399 of
in
2014.
MAT 1399 are not germane for disposal of the present appeal. The MAT 1399 arose from an order passed in a proceeding instituted by Moina Gop, sister of the writ petitioner.
2013.
Instituted by sister in 2013. Moina Gop had entered into an agreement for sale of the land of the property.
Her share.
Agreement for sale of her share in the property with the appellant. Full stop. Her grievance was with regard to illegal parking on her portion of the land by the appellant. Noting the arbitration clause in the agreement for sale, the aforesaid alleged wrongful use by appellant was relegated to a civil proceeding, full stop. In light of the aforesaid discussion, we are of the opinion, proceeding, full stop. Having taken note of the findings, we approve the findings of the Commissioner of, we approve the findings of the Commissioner of Police in the report and accordingly hold no further registration of FIR is necessary. Needless to mention, the criminal cases lodged by the respondent, writ petitioner respondent, as well as the appellant shall be investigated fairly and in accordance with this observation. Appeal is
Much obliged.
all right.
Much obliged.
Next,
Lordship 35, I appear for the petitioner's lordship virtually.
yes, next matter.
Lordship, I beg to appear for the petitioners virtually in 35 lorships.
Huh?
Lordship, I beg to appear for the petitioners virtually in serial 35.
Yes, very good.
Lordship, this is a GST matter. The learned single bench,
Yes.
Lordship, the judgment of the learned single bench is at page 31 of the stay petition. Lordship, the issue in this was regarding the interpretation of section 54 of the CGST Act and the WBGST Act, wherein whether the 60 days as given in the statute for the department to pass a refund order is mandatory or directory. Section 54 uses the words shall, that the officer shall pass an order within 60 days. And in my case, Lordships, the department, without assigning any reasons, has passed an order rejecting my refund claim after 2 days. Second Lordship, the issue was after 2 days, Lordship, because the Lordship under Rule 89, the procedure for refund has been established in the code. The GST Act is a code in itself, Lordships. The Act provides for certain
But
timelines.
56 provides for interest on delayed refunds.
Lordship, that is only in a case when a refund is accepted.
Correct.
My case is a case, Lordships, before your office, that after the first appeal, because the GST tribunal is not formed, we had to file a writ petition under Article 226.
That is
now, we argued on 2 points, Lordship, as to the interpretation of section 54(7), as well as on merits of my claim, merits of my refund claim.
Now, merits have to be gone into.
But Lordship, the learned single judge dismisses my writ stating one line. Lordship, may kindly take para 14 of the judgment, stating
Yes. So far as the merits for refund, that should have been gone in.
Lordships.
On the point of limitation, the Honorable Single Judge's view is well taken. In light of the provision for
Lordship, but I would like to argue on that point, Lordship.
Okay, if you argue, we are holding it against you.
Lordship, then fine, Lordship.
If you are arguing, you are holding it against you. However, if you concede on that point, we will revert the matter on the issue of refusal to be considered afresh upon exchange of affidavits. All right,
dear Lordships, fine, Lordship.
Appellant contends that the time frame within which refund is to be made under section 54 of the IGST Act,
CGST stroke WBGST, Lordship.
CGST/WBST Act, GST Act is mandated. He also submits, is mandatory. He also submits where is the time given?
Lordship, section 54, Lordships.
Correct. Which part?
Lordships.
Huh? 7. The proper shall within 60.
Lordship 54(7), Lordship.
Right. Now,
Lordship, actually, there are certain contradictory views in this impugned order. Just 1 minute, Lordships. Can I take your time, Lordships? Lordship, the learned single just says the rules are directly the rules framed for giving.
sir, we are holding 56, giving a provision for interest on delayed pay refund. Our understanding is not only the consequences of a refund beyond 50 days, not spelled out. On the contrary, interest being prescribed, the word shall has to be read as may. Correct?
Lordship, but that is only in the case where my refund is accepted.
Oh my God, sir, the second point we will come.
Grateful to you, Lordship. Grateful to you.
And we will hold that this question doesn't arise at all because your application was dismissed.
Fine, Lordship. Lordship, in that case, it can be remanded to I can be given an opportunity to go before the tribunal because the tribunal is being formed in the coming months.
Has been formed.
Lordship, the notification is there. It is proposed
Judges have not been appointed as yet.
Lordship, what as per the GST Council's meeting, Lordship, it is to be operational in this year. Maybe
Next circuit.
Lordship, may kindly give a direction,
Yes.
Lordship, I beseech to your Lordships. Lordship, I apologize. Lordship, I apologize. Lordship, may pass such orders. Lordship, may pass such orders.
This is the problem with tax law here. Yes.
36 Lordship, on behalf of Mr. Ikramul Barim, bring for next circuit. Is out.
Sir, please. Yes, so and so Mr. Balmon for state. Next matter.
Well, I'm for 37, my lord.
Yes.
Well, may I, my lord? But it is GST matter, my lord. Well, it will take some time, my lord, if your lordship, my lord.
Monday.
No, my lord. Today itself, my lord, after recess, my lord. Otherwise, I can start, my lord. It will take at least 15 minutes, my lord.
We will continue now.
My lord, before the. But this is a detention, seizure, and thereafter, my lord, the petition went for an appeal, my lord. My lord, there are 3 rounds of litigation before the single judge.
Can you keep it? Will it be difficult for you to argue on Monday?
My lord, again, I'll have to come from Calcutta, my lord. My lord, may I begin, my lord?
Yes.
My lord. My lord, the first round of litigation was, my lord, I challenged the detention of the goods, my lord. My lord, Justice Nijamuddin, my lord, he passed an order, my lord, Honorable Justice Nijamuddin passed an order whereof it was directed that I go to the authority, pay the penalty proposed and get the goods released. My lord, thereafter, let me complete. This is my petition. This is not your petition, madam. My lord, thereafter, my lord, I went for a second, I went for an appeal. The order was passed. I went for an appeal, and thereafter I came to this writ court, my lord. My lord, I'll place the order, my lord, which is in page number 50, my lord. Honorable Justice Amrita Sinha, my lord. 50, my lord. The fact of the matter, my lord, I'll just read it out from this order, my lord, which will be very clear, my lord. My lord, the second line, my lord. An escalator machine JCB of the petitioner returning from work, my lord, it was job work, my lord, was intercepted by the officer of the Bureau of Investigation, North Bengal, Alipurduar zone. The driver of the vehicle failed to produce any document in support of the movement of the goods, that is JCB machine, my lord. My lord, thereafter, my lord, 51, my lord, page number, my lord. But the adjudicating authority passed order against the petitioner, and appeal was carried out from there before the appellate forum, which too stood rejected. The petitioner has held liable to pay a penalty of a sum of rupees this in contravention. My lord, thereafter, the last paragraph, my lord, the petitioner submits that the machine in question was being transported with a valid e-waybill, my lord. My lord, under rule 138A, my lord, a challan as well as a e-waybill has to be carried, my lord. My lord, thereafter, my lord, 52, my lord. In fourth line, my lord, non-availability of the delivery challan with the vehicle is a mere procedural impropriety, and the petitioner did not have any intention to evade tax, my lord. It was submitted on behalf of the petitioner, my lord. In support of the last paragraph, my lord, in support, page number 52, my lord. In support of the submission, the petitioner relies upon the judgment delivered by the court of Uttarakhand
Pestrous Steel, my lord. This and division bench, my lord, of our court, my lord, in the case of Usha Martin, judgment delivered by Allahabad High Court in Bharti Airtel, my lord, and thereafter, my lord, our division bench, my lord, KD Gupta and company and others, my lord, page number 53, my lord, I'm reading it, my lord. The reliance has also been paid up, placed on circular number 64. This, my lord, the petitioner pays for setting aside of the order passed by the appellate authority, rejecting the appeal preferred by the petitioner. Thereafter, the state respondent, my lord, on the third paragraph, the state respondent opposes the prayer of the petitioner. It has been submitted that no document in support of the movement of the vehicle could be produced by the driver at the time of interception. My lord, thereafter, my lord, the rule are given, my lord. Thereafter, the last paragraph, the adjudicating authority and the appellate authority noticed that the vehicle in question was not released by the person as recorded in the e-way bill. The same was released by some other person. The delivery challan was also not signed, my lord. Well, there are three allegations against me, my lord. One, I was not carrying the delivery challan. Thereafter, my lord, after and before the detention, delivery challan was placed, my lord, and the goods were released by some other persons, my lord. My lord, page number 54, my lord. My lord, page number 54, my lord. I have heard and considered the submission made on behalf of both the parties, my lord. May I read it, my lord?
Come to the page 10 of the impugned order.
Well, page 10. My lord, page 10 of the impugned order.
The thing is that e-way bill was subsequently given. You say that there was no intention to evade.
My lord.
May have been an inadvertent error. It was not being carried. Correct?
My lord.
Now, the finding is that the entries in the e-way bill and the delivery channel, they don't match with one another.
My lord, my lord. Page number 57, my lord. Page number 57.
See the what?
Oh, yes, my lord, order, the penultimate paragraph of the order, my lord, 57. In the present case of the writ petition, my lord.
What penultimate? What is the page in the order?
My lord, page number 8 of the order, my lord.
8 of the which order?
Justice Amrita Sinha's order, my lord.
Huh?
Justice Amrita Sinha's order, my lord.
Yes. Justice Amrita Sinha's order. This.
Starting from page number 50, my lord.
Huh? We are not concerned about Justice Amrita Sinha.
My lord, that is, my lord, kindly bear with me, my lord. My lord, there was a specific direction. He will not be an appellate authority, my lord. If Honorable Justice Amrita Sinha's order was to complied with, my lord. He has sat upon that order like an appellate authority, my lord. My lord, that cannot be, my lord.
Can be. Justice Amrita Sinha's order is not a fact-finding order.
But categorically, my lord, the fact has been laid down, my lord.
May be laid down. That was only on the basis of pleadings. An inquiring authority is empowered to look into facts appropriately and come to correct findings.
My lord, my lord.
Observations by a court in judicial review does not bind it.
My lord, page number, my lord, lordship is on page number, my lord, of the
clearly satisfy us. Delivery channel and e-way bill were the same, one and the same.
My lord,
I'll do order.
My lord, page number, my lord, lordship is in page number, my lord. Page number 10 of the order.
Now come to page number 10 of the impugned charge.
The alternative argument of the petitioner is that
we have seen alternative argument. Next, countering this.
Countering this, it has been submitted by the revenue in the e-way bill. My lord, this was the revenue submission. My lord,
this revenue submission is important for you.
I'm reading it.
Please read it.
Countering this, it has been submitted by the revenue that in the e-way bill generated on this, which was valid on till 26th of April, the GSTN of the supplier was mentioned at PC Surya Singh, who is an unregistered person.
Very good.
The delivery challan, which was produced by the writ petitioner, shows that the said JCB was released by DAMIK Grami, proprietor of BG Enterprises. The delivery challan is a letter written by the on the writing part of BG Enterprises, Arunachal Pradesh, and is not signed by the consignor or his authorized representative. The delivery challenge so issued by BG Enterprises, Ghani Market, Darijipo, Arunachal Pradesh, my lord. Even if it is considered to be a valid document, the information given therein does not match with the e-waybill which the consigner is PC Singbo. Well, to this extent that the difference was only as regard to the person who is sending the goods back. Well, it was not, my lord, I'll satisfy. Well, this was my person, my lord, who was interested to look into the JCB, the working of the JCB over there, my lord. The goods were released. My lord, the goods were released, my lord. I generated the e-waybill and accordingly, my lord, as because
the e-waybill and the delivery challan are not matching one another. Is this the fault of the authority to impose penalty on you?
no, my lord, it was matching, my lord. It was matching. Only the goods were not released by BG Enterprises. This was the discrepancy, my lord.
Then
My lord, but it was covered by all the documents, my lord.
what is covered by all
But
documents?
the e-waybill was over there. E-waybill as well as the JCB, my lord. My documents was considered at the time of imposition of penalty. The goods belongs to me, my lord. It was not transferred. My lord, Section 9 of the GST Act says, my lord, if the goods has not been transferred, my lord, there cannot be any tax upon that, my lord. My lord, I have not received any consideration as per Section 9, my lord. My lord, it is, and my lord, there is no mention as regards to the imposition of penalty, my lord.
So the services rendered by the JCB
My lord.
was
In Arunachal Pradesh.
by whom?
By me, my lord.
To which entity?
My lord, BG Enterprises and my lord, to BG Enterprises.
But in your e-bill, you are saying Singapore.
My lord, my lord. My lord, lordship
And
comes.
thereby BG Enterprises
I
will
understood.
have the advantage of evading the tax which they are supposed to pay
No, my
with
lord.
regard to this.
My lord, in Arunachal Pradesh, my lord.
Yes.
Well, I am supposed to pay the taxes, not BG Enterprises, my lord. I am supposed to pay the taxes in Bihar, my lord. The goods were sent to for a job work at Arunachal Pradesh. The goods were returning back, my lord. By on a valid waybill, my lord, it has gone. It is being returned to the original owner, my lord. Lordship comes down to page number, my lord, 86 once, my lord, of the order, my lord. My lord, here it is written, my lord, inner page, my lord, page number 11 of the order. My lord, from the bottom, my lord, 6-7 line, my lord. The tax invoice of the such JCB in the name, my lord, before that, my lord, if the writ petitioner was the owner of the JCB and has sent the same to the Arunachal Pradesh for job work, then the writ petitioner will have the tax invoice of the JCB in his name. There will be an e-waybill by which the JCB was taken to Arunachal Pradesh for job work as claimed by the petitioner. Now, my lordship comes down to page number 23, my lord. It was on record, my lord. It was on record.
What?
My lord, these documents, my lord. From the bottom, my lord, third paragraph. At the time of physical at the time of physical checking of the goods loaded in the vehicle of the loaded in the driver in the vehicle, driver of the vehicle handed over some documents, insurance document, tax invoice, purchase document of hydraulic excavator bearing this, a letter of regarding release of hydraulic excavator along with the delivery charge. All those documents were filed, my lord. It was on record. And he writes, my lord, in page number 86, which could have demonstrated that there was no evasion of tax. My lord, if those documents were produced, my lord, I have already produced those documents. It is in record. And what was the inconsistency, my lord? 24, my lord, if lordship comes down, my lord.
These documents are documents of ownership.
My lord.
What you are indicating to us, insurance, tax invoice, purchase document of hydraulic excavator
My lord.
are ownership documents.
My lord.
What his lordship observes in page 11
My lord, please,
is
yes.
the invoice with regard to the use of this JCB
My lord.
by a entity who is unclear. The fact that your JCB is utilized by an entity, is it Singapore? Is it BG? That is unclear.
My lord,
And that is relevant for the purposes, as he indicates, as lordship indicates, for the purpose of imposing tax on the services rendered by the JCB, right? In this situation, the delivery challan not matching with your e-way bill,
my lord, I'll explain, my lord.
because it is the e-way bill on the basis of which you are to pay the tax under your GST-IN number.
No, my lord.
Right?
My lord, GST is imposed on supply of goods as well as supply of service.
Well, that is
When it is a-
that we have no doubt.
My
We
lord,
are saying
my lord, this was a supply of service, my lord, not
Got it.
my lord,
So-
JCB.
So
My lord, my JCB will not be earning that amount of tax, my lord, which was the value of the machine, my lord. Only to the extent of
the e-way bill will show the person who is entitled to take input tax credit on the basis of tax paid by you. Isn't it?
No, my lord.
No.
My lord, very sorry, my lord.
Only
My lord, I'll explain, my lord. My lord, e-way bill is a document for the movement from one state to another or in the interstate also.
very good.
My lord, the tax is levied on the supply of service on the invoice raised
But
for
where
that
is
service.
that invoice?
My
That
lord,
is
it is
exact.
reflecting. It is reflecting in my returns, my lord.
Where is that invoice?
My lord, it is reflect. My lord, if at all, my lord,
Where is
my
that?
lord, I'll
invoice?
my lord.
That invoice was not supplied.
My lord,
If that invoice matches with Singapore, no difficulty.
my lord, those invoice, my lord,
Or if that invoice matches with BG, it is all right.
my lord,
That will be an
my lord, I'll submit,
inadvertent
my lord.
error.
My lord, I'll submit.
Supply, place
My lord,
on record
one
those
that-
invoices.
My lord,
Show us the invoice with regard to this work done.
my lord, I'll be filing a supplementary, my lord, in that case.
Place on record.
My lord.
Place on record.
My lord.
Yes, Mr. Shah, what do you say?
As per section 60 of the GST Act, my lord, a person is.
Madam, one thing we need clarification. Whether the consignee or the person to whom the contract was, the service was rendered, the incorrect description of the person, is it a material error in the way bill? If it is an inadvertent error, then it would not be something on which you impose penalty. Is willing to pay the additional that 25,000 rupees under 129(1)(b). But he says that you are imposing 100% penalty on him, provided there is an intention to evade that. If an incorrect description of the person to whom the service is rendered is given in the e-bill, will it be something which is an intention to evade the tax? Because he says in his return, he has put in the invoices with regard to the user and he is paying the tax.
May I explain, my lord? In what way? my lord, under 138 rule, my lord, it says an invoice and a e-way bill has to be carried, my lord. I am a registered dealer at Bihar. My lord, I generate a e-way bill from the portal at Bihar, my lord. Now, my lord, I take it, my lord. Now the assessing authority of Bihar is to look into this factor, my lord. My lord, whether I paid the tax or not, my lord, it is to be as because it is recorded, my lord.
Then if that is said, they are absolutely right in imposing penalty. They
Well,
are absolutely right.
I'll place on record the invoices, my lord,
We are
raised by
not
me.
concerned. Yes, make your submission.
This person is sending his excavator to Assam. And in exchange, what he is getting, my lord, he is getting,
Sir,
renting.
His
Right.
rentals and he is entitled to pay tax.
Service tax, my lord. Now, when he's entitled to pay service tax, my lord. Now, the ITC, which he will claim, my lord. The provision of section 16 says that until and unless a good is being received, my lord, a person cannot claim ITC. The person who is delivering, my lord, section 16 will be attracted, my lord, and that is to be required to be proved, my lord. Now, if this person is not showing that his excavator was actually sent on a rental
By BG.
by BG, my lord, there is a evasion of tax, my lord.
The PC Supriya Singpo is in the e-way bill.
He doesn't have a GSTN number.
Right.
He's not required to pay any tax, my lord.
And so far as
BG is concerned, it's a registered person.
and the delivery challan is of BG.
Yes, my lord, it's a registered person, my lord.
And he will take input tax credit with regard to BG.
My lord, may I, my lord? My lord, this is a return of goods, my lord. There is no question of input tax.
We know there is no question of input tax.
My lord,
You don't
section-
understand what we are trying to look into.
My lord.
We are seeing whether the misdeclaration is an innocuous one or it has far-reaching impact on your liability.
Well, I'll file the documents, my lord.
No way. We have understood. Take the.
But the invoices, my
Don't
lord,
take the
lordship has
trouble
asked-
again.
My lord, lordship has asked for the invoices, my lord. It can be
Yes.
filed, my lord. It is in the
All right.
in the portal, my lord.
Appellant has a sale judgment and order dated 24th May 2024, passed by the Honorable Single Judge, dismissing his challenge to the impugned. Where is the order? Page 23. Impugned order of detention. Page 23 is the impugned order which is challenged.
Detention 22. Thereafter, focus on it and thereafter, original.
Yes, impugned order of detention of the JCB machine. In contrary, JCB machine, which was being JCB machine, and where is the order imposing penalty? And the order of penalty.
27 March 24.
You have challenged the order of penalty alone. The detention was challenged earlier, right?
Yes.
Detention order, no, order of penalty under section 129(3) of the West Bengal GST Act 2017, imposing a penalty equal to 200% of the tax payable on such goods. that is 9,93,080 only. Good stuff. The brief facts giving rise to the appeal are as follows. Officials of Bureau of Investigation, North Bengal, Alipurduar, had detained a goods vehicle, detained a JCB machine bearing registration mark NL01N80141 on 21/4/2023. Driver of the vehicle handed over a e-way bill dated 18/4/2023 for transportation of the vehicle from Arunachal to Bihar. He, however, failed to produce tax invoice, delivery challan, failed to produce them. He had produced a e-way bill at the time of detention. Then why are you saying that he failed to produce an e-way bill?
He produced the email bill, he did not produce the delivery challan.
Correct, correct. However, he failed to produce tax invoice or delivery challan at the time of interception as per law. Statement of the driver was recorded. And physical verification and upon physical verification of the vehicle, in various documents, including a delivery challan was noted. Inspection of the delivery challan showed inspection of the delivery challan revealed that it was not in terms of, it does not contain the particulars as prescribed under Rule 55 of the CGST and /WBGST rules. It was not signed by the consignor or its authorized representative. The delivery letter also from the delivery challan, it appears that it was issued with regard to release of Hyundai excavator 215 by Damic page 61 full stop by so and so, issued by Messrs. BG Enterprise, Arunachal Pradesh. The delivery challan, however, the e-mail bill carried by the driver, produced by the driver at the time of interception, discloses, shows e-way bill produced by the driver for transportation shows it was issued by PC Surya Singh Po of Arunachal Pradesh, an unregistered person. Unregistered person. Accordingly, show cause notice was issued upon the appellant, who responded. Accordingly, detention order dated 23/4/23 was passed and show cause notice was issued upon the appellant
On 26 April 2023.
on 26 April 2023, and order of penalty confirming 200% tax came to be passed on 3/5/23. The order was assailed before this court in WPA 85 of 2024, and a honorable single judge remanded the matter inter alia for reconsideration. Pursuant to the said direction, the respondent authority passed the impugned order reaffirming the penalty. This was again challenged in the present writ petition, which was dismissed by the impugned order. Mr. Your full name, sir? Mr. Churalia contends the adjudicating authority, contends the adjudicating authority ignored the observations made by the honorable single judge in WPA 85 of 2024 to the effect and sat in appeal over the said finding, and sat in appeal over the said finding. He also contends over the said finding, he contends failure to carry the delivery challan was an inadvertent error and there was no intention to evade tax liability. Full stop. On the other hand, Ms. Sarkar, for the respondents, submit the issue which persuaded the adjudicating authority to impose 200% tax liability was not mere failure to carry delivery challan, but the fact that the delivery challan subsequently submitted by the assessee was submitted by the assessee did not match the e-way bill in material particulars. Full stop. Issue which falls for decision. Now, admitted facts on which the following facts are admitted. A JCB bearing registration mark so and so was detained by Bureau of Investigation on 21/4/2023 on the ground that inter alia on the ground that the driver was not carrying original duplicate copy of tax invoice delivery challan. Full stop. But during physical checking of the goods, after detention, after intercepted, but during physical verification, physical checking of the goods on a delivery, on 22nd April 2023, a delivery challan showing release of the JCB by inverted comma Game so and so proprietor BG Enterprises issued by the said proprietor was placed on record. Was placed on record. It may be appropriate to note that the e-way challan, which was carried by the driver, e-way challan carried by the driver, e-way bill generated by the appellant's firm for transportation of the goods show one PC Surya Singpo of Arunachal Pradesh as the consignee of the consignee or consignor. Should be the consignee. The consignor because he's sending. That's why it's as the consignee of the JCB concern. The consignee in the e-way bill, that is Singpo, PC Surya Singpo, an unregistered person, inverted comma. Now, however, the consignor, however, the consignor of the delivery challan is a different entity, that is Messrs. BG Enterprises.
When a consignee is PC Suraj Simpu, my lord, consignor is the petitioner. That is why the case is in the name of the.
However, the delivery challan, yes. However, the delivery challan is issued by a different entity, that is BG Enterprise, Gandhi Market, Dapur Geo, Arunachal Pradesh, GSTN, so and so. Full stop. This unequivocally show that the delivery challan subsequently submitted by the appellant does not match the e-way bill generated in favor of PC Surya Singpo. Noticing the aforesaid discrepancy, the adjudicating authority imposed penalty. We are not imposed penalty. Imposed penalty. Full stop. In the first round of litigation, the order of penalty imposed had been set aside by the Honorable Single Judge and matter remanded for fresh consideration on an observation that the appellant did not have intention to evade tax. It may be relevant to quote the observations of the Honorable Judge as follows, page 57. Full stop. The aforesaid observations, the page 67. Relying on the aforesaid observation, Mr. Churalia contends the adjudicating authority ought not to have gone into the irregularity, gone into the mismatch between the consignee as per e-way bill generated by his client and the delivery challan submitted later on. And later on, we do not find merit in his submission for the following reason. Delivery challan, for the following reason, mismatch between the consignee, for the following reason, in the e-way bill generated by the appellant, the consignee so-and-so is an unregistered entity, whereas the delivery challan placed on record, subsequently placed on record, shows one Messrs. BG Enterprise, a registered an entity bearing an assessee under the GST Act, under the appropriate GST, under the appropriate GST Act. The mismatch, this mismatch is not an inadvertent, innocuous error, but would give opportunity to the would but would give opportunity to the appellant to misutilize the subsequent delivery challan and obtain credit and obtain input tax credit for supply of services to a registered entity. This issue did not fall for consideration before the earlier round of litigation. This issue had not been considered in the earlier round of litigation, and the observations, earlier round of litigation, full stop. Observation, accordingly, it cannot be said, accordingly, it cannot be said the earlier round of litigation and the observation made therein cannot be said to have binding effect on the fact-finding adjudicating body, to which the matter was remanded. In light of the aforesaid discussion, we are of the opinion the findings of the Honorable Single Judge are well merited and does not call for interference. The appeal is accordingly dismissed.
Tax invoice is where the tax is charged. Delivery challan does not contain any tax mark. So there is no question of getting that.
Yes. The delivery challan.
In delivery challan, there is no ITC. There is no question of charging any tax.
The delivery challan you will not use the delivery challan, but the delivery challan will be utilized if any inquiry is made with regard to a credit for supply of services to a registered entity, that is BG Enterprise. Whereas your e-generation is to sing.
There's a revenue generation which has been.
All right.
So delivery challan date has to be mentioned. Dated by delivery challan is
10/6.
10/6/2020.
Right. Next.
But by spelling, not Churaria, it is not Churaria, it's Churaria.
Please give it in. Thank you.
My lord, I am further respondent. My lord, the copy has not been served upon the respondent, so I am praying to fix this matter in the next circuit, my lord.
All right. On the prayer of the respondent, adjourn till the next available circuit. Next.
Lordship, in this matter, Learned Reggie is appearing in this.
Milord, may I assist your Lordship, Milord, online?
Yes.
Appearing for the respondent.
Oh, appellant is here. We are not. Yes, Mr. Moinak Bosch is there.
My lord, has your lordship called item number 39?
Yes. Yes, 39.
Yes, well, my lord, I am for the appellant.
Yes.
My lord, this appeal.
This will take some time.
It would, my lord. It is.
Milord, I have a
arising out of a contempt jurisdiction and order.
Mr. Advocate General wants to wrap it up quickly. Yes, Mr. Advocate General.
Milord, the contempt application, Milord, has been disposed of with certain directions without punishing for contempt. Now, Milord, the point is made whether refusing to punish would be a judgment within the meaning of clause 15 of the latest patent. Where there are judgments, Milord, from Baroda Kanpur, Mishra and all. That
Yes,
where
refusal is not an appealable order.
Well, that is not even
Dismissal
the
of a
scope of
contempt
the
is
appeal.
not an appealable order, Mr. Moinak Bose.
Well, allow me to, well, my learned advocate
But
general
only
has said
thing, Mr.
whatever he had
Advocate
to.
General,
Yes,
if some consequential orders are passed,
yes,
it affects which has civil consequences, or maybe
on that part only.
on that part.
To
I'll
that
tell you,
extent,
Lordship, what has
let us
happened
say,
is.
we don't know what is the gross delay in
I'll tell you, Lordship,
order.
kindly bear
One
with me for a
second.
moment.
Inordinate delay, timeline, more stringent, accepting apology. Appropriate order. Do we দিয়েছে একেবারে না Monday.
No, my lord, kindly have, my lord, what has the
Nothing.
learned judge done in the contempt jurisdiction?
Yes, Mr. Moinak,
It
both
has,
we will require deep and extremely learned persuasion. So we are keeping it in the next available circuit. All right.
my lord, in fact, my lord, instead of
Our
the best circuit,
faculties are not as evolved to take this, all right? So go for the next available circuit.
no,
That's
but
the
it
best.
has to be before your
Suppose
lordship,
that is
because
the
your
best
lordship
thing
has
we can do
exclusive
for you.
contempt jurisdiction.
Yes.
Your lordship, my lord, this is a appeal arising out of a contempt jurisdiction. So your lordship only has contempt jurisdiction. So whether it is before the regular bench or circuit bench, my lord, it is your
So
lordship who
circuit
has to
bench
take it.
will the jurisdiction conferred is of
Yes.
the principal bench.
Right.
So far as the jurisdictions apart from the public interest jurisdiction under the rules are with the division bench who are sitting in the circuit. So your appeal will be taken up by the next available circuit.
Very well.
Not by
Very
us, because we have the contempt appeal jurisdiction in the principal bench. That is for
Very.
appeals in the principal bench. All right.
Very
Because this will, as we said, we will break grounds again if we admit the appeal. So let it be done by more wiser heads. Yes. Next.
I'm
matter.
grateful.
Yeah. Grateful.
I for the petitioner respond.
Yes. Section 5. Condone.
60 days.
All right, condone. All right, delay is condone. That we are bound to act the application of mine, once decision has been taken in the mayor in council, the commissioner ought not to have reopened the issue. After accepting the detention fees, it is absolutely improper for the commissioner to revoke resolution. Court is of the opinion. So retention fee, illegal construction permitted, nagi?
Yes, no, not sure what.
Certain construction work without obtaining. Wow.
The provisions of their mind.
Yes, Mr. There was no sanction plan.
No, I just madam. Because can you see the single judge why pass the order? But this is not the final order, it was the order, input order. Ask them to consider it. Can you see at page 32?
In terms of the resolution.
In the my can you see? Marine Council having the power.
Power of what?
That to regular in terms of section 400 of the Calcutta Municipal Corporation. That section is there.
Calcutta Municipal Corporation.
Yes, they can apply it. Yes, they can apply it. I just place it. Was it two years? I can see. At a to them. Section 2. Section 373.
West Bengal Municipal Corporation.
No, this is new. This is 373 capital.
373
capital. They apply the section. They can exit. Municipal Corporation in exercise this power, they can, my lord, take help of Calcutta Municipal Corporation Act. They have said in their own order. Can you see, my lord?
Where is the resolution?
Page 19.
Page 19.
It starts on page 18.
Page 18 is page 19.
No, it starts from page 8 to page
19.
Okay.
Findings on the left hand side, as per inspection report, the construction of the state.
Can you see
building
who
has
has
been
taken? Maybe because it's authority, my lord.
But Mr. Rai.
Yes, ma'am.
Just read para 25.6. There's a evidence case charged. In that, the single held that the commissioner has stopped that. And the medic company was empowered with that.
But then where is the provision for retention charges?
Yes, my lord, this section is there in the Calcutta Municipal Corporation Act.
How do you apply the Calcutta Municipal Corporation Act?
370, that power is given there.
How?
With the state government. I can't see.
Huh.
Only will appreciate.
Where is the approval of the state government?
But this is, they can't say whether they approve.
No,
Because
there's
they-
no approval.
Once they have now.
Have you taken a ground that there is no approval of the state government?
But they have their own.
1 second, have you taken a ground that there was no approval of the state government?
We had said, no, first what had happened.
We are asking you, is there approval of the state government for applying retention fee by the?
We had sought for clarification from the state government. The state government has said that it cannot be done. Yes, we have taken a ground. We have taken a
Where is that? 21, there is no provision. Paragraph 21, page 10.
There's no provision is there.
You are saying there is no provision. They are saying 373A.
373A subject to that, the prior approval of the state government has to be.
Sir, that is what we are saying. File a supplementary affidavit, whether there is a prior approval
No,
or
there is
not.
no prior.
Appellant contends there was no provision empowering the mayor in council to regularize the illegal construction by imposing retention fee. Mr. Rai, senior counsel, refers to section 373A of West Bengal Municipal Corporation Act. 373A reads as follows, set up. A bare perusal of the aforesaid provision would show that the corporation, that the appellant corporation is empowered, in the event the appellant corporation is of the view, provisions of Kolkata Municipal Corporation is more befitting than the provisions of the West Bengal Municipal Corporation Act 2006, the said the provisions of Act of 80 may apply to a case or class of cases subject to the approval, subject to prior approval of the state government. Learned counsel for the appellant seeks leave to file supplementary affidavit, placing on record the fact that no prior approval had been taken by the mayor in council. There was no prior approval to invoke the provisions of the Act of 80 and regularize the illegal construction on deposit of retention fees. Supplementary affidavit we filed
Within 1 week.
within 1 week. matter will appear before the next.
Exception I'll give.
Let it be filed exception I will give. Matter will appear before next available Sunday.
I will.
Next,
The next matter, I am for the writ petitioner respondent, identical matter, my lord.
same order.
Same.
If they can show prior approval or you can
My
give
lord.
prior approval in
My
your,
lord, no, my point is different. I'm just giving.
your
my
point is different. You are showing
No, I'm not. I
353
said
and
that-
point
no,
is
they-
different.
yeah.
Next. Delay করুন।
Release content.
42,
Order to Millard, we are for the private respondent number 7. Writ petition.
Monday, on the prayer of the appellant, Monday.
I'll still rise up. Or I'm not going to take it. You'll still rise up.
Yes. We'll finish.
43, my lord, may I be permitted?
Yes. Yes, next matter.
My lord, 43, I beg to appear for the appellants, my lord, virtually.
43 for appellants, respondents. So and
My
so
lord, it
forth.
has been served, my lord. My affidavit of service is with my
Yes.
advocate on record,
Is
my
there
lord.
any delay?
My lord, there is no delay, my lord. My lord, the entire appeal can be disposed of, my lord. It is the
Monday.
interpretation
We are
of
keeping it on Monday. All right.
It's deeply obliged, my lord.
44.
My lord, there is a short defect in my lord, in my matter, my
Defects
lord.
be
If that
removed in the
could be
meantime.
grateful, my lord.
Not have served. Well, I beg to appear for the bank. Respondent. May I file the affidavits of service?
Yes.
My lord, the writ petition was filed by the bank, my lord, with 2 prayers. My lord, I am a borrower, my lord. There has been irregularity in repayment, my lord. The 2 prayers, one, prior to that, there was a direction by under section 14 of the SURFACE Act, directing the concerned officers to take physical possession, my lord. Now, what has happened? 2 prayers in the writ petition, my lord. One, direction upon the district magistrate's order to be complied, and second, my lord, that prayer that I shall be restrained from alienating the property. Now, what has happened, my lord, after the filing of this appeal, during pendency of the appeal, my lord, the physical possession of the
Handed over.
has been taken, my lord. Now, my lord,
And
here,
what
my lord,
would you-
yes, if I,
you will be at liberty to take up all your points before the debt recovery tribunal.
he is for the bank. And for the bank, we have.
Oh, you are for
I am the borrower, my lord.
to borrower, but
We have already taken
appeal has
for the
become
physical
infructuous.
My lord, if your lordship, yes.
In
but-
view of subsequent development, that is taking over physical possession of the secured asset, the appeal.
I'm sorry to interrupt, my lord, but if your lordship kindly considers few points, my lord, I'll just take few moments of your lordship's, my lord. Now, talks of OTS is going on, my lord. I have till date paid 1 crore. We have given an offer of 15
We
crores.
will make that clear.
And my lord,
Appeal has become appeal and the writ petition has become infructuous. Accordingly, appeal is disposed of. Observing, it shall be open to the appellant borrower to negotiate with the bank and arrive at an one-time settlement as per relevant rules.
subject to approval of the bank.
How to enter into
Yes.
negotiation with the respondent bank?
Negotiation is going on. We have
For-
paid 1 crore.
We are saying it will be
I'm sorry, I'm
open
sorry.
to arrive at a one-time settlement as per the extant rules.
Correct.
Pendency of any negotiations, however, shall not stand in the way of the respondent bank to take action to pursue its remedies in accordance with.
Good. Lordship. May I file the affidavit of service?
Yes, restoration matters. Applicants
And for the private dispute, 75.
All right, Monday. 45, Monday.
Problem.
46 restoration.
Lordship.
Restore.
It's a recalling application, not a restoration.
Then how can it has to be by the same bench, no?
Recalling, sir. Yes, but a recalling application.
Recalling application, it was disposed of on merits.
They have withdrawn the application. If you don't see the order. Lordship. They have withdrawn the.
It goes to the appropriate bench.
But Lordship, I prefer this one done by some mistake only by advocate, and my client is here. So if it will be supposed to be in principal bench, it's against create a long detention for my client.
How, if it is recalled, then how can we again, if it is
Lordship,
withdrawn?
grant me leave, I can.
What leave?
Already 16 December.
In view of the nature of relief sought for, we are of the opinion the application requires to be placed before the honorable bench, coordinate bench, which had passed the earlier order, dismissing the appeal, dismissing the appeal. It's a recalling order. It will be, in fact, this will be a review. How can it be recalling? Recalling is an ex parte.
Lordship, then give us the opportunity to
We are just placing it before the appropriate.
that I'll do, but Lordship, if limitation ground, if your Lordship may kindly.
What limitation ground? We have already taken out an application. What limitation ground?
No, if I'm supposed to file the review.
I've never said that you are filing review. You said in view of the nature of the relief sought for and the order impugned, we are of the opinion the matter requires to be placed before the honorable coordinate bench, whose order is which passed the order sought to be recalled.
Lordship. Lordship, my little bit of service may be taken on record. Huh? এখানে তো করে দিচ্ছি আবার ফেস সার্ভিস খেলায় ফাইল মাই এফিডেভিট অন সার্ভিস কাইন্ডলি হ্যাঁ সেটা করব আমি করব
Yes, next matters.
It's my second appeal, my lord. Please take Monday.
I was
Monday.
only bring it.
I accept.
Monday. All will be Monday. All will be Monday. Don't worry.
No, the second appeal, I additional evidence.
Request some time.
We'll keep it on Monday. Next,
48, my lord, my April.
Monday. Monday. Forty-nine.
My lord, item number 49, my lord. My lord, item number 49. My lord,
Yes.
in this matter, my lord, I am appealing for the appellant state. My lord, this is an appeal. My lord, filed, my lord.
Defects are there.
My lord, defects I cured, my lord, before, my lord, by having my lord, reached to the Jalpaiguri bench also, my lord. Personally being present before your lordship, my lord, I also corrected the defect, my lord. Your lordship.
All the defects have been removed.
Yes, my lord, defect has been removed.
All
By
right,
honorable
Monday.
Monday.
On the prayer of the appellant, Monday. Next.
Monday.
My lord, I am appealing for the appellant plaintiff. Worship, there's a direction to file affidavit, so, my lord, I have served and I'm filing the
Yes.
My lord, the matter is relating to the, my lord, the partition suit filed by the plaintiff appellant. My lord, my lord.
Preliminary decree or final decree?
No, lordship, no, the partition suit was, my lord, dismissed.
Oh.
Because, my lord, the appellant is the adopted son of the person from whom he has got the property.
All right, the appeal will be heard.
Appeal will be heard.
Bas.
First appeal, my lord, the LCR is required to be.
TCR we called for, appeal will be heard, notices be issued upon the respondents. Appellant shall prepare paper book. Please give that format of the order.
Lordship, lordship.
For one of the respondents. number 9.
So and so appears for respondent.
My lord, the affidavit of service ticket.
Other respondents, so and so enters appearance, notice be issued upon the other respondents. Notice upon so and so respondent is dispensed with. Trial court records be called for. Appellant shall file paper books.
Grateful, your lordship.
Please give us how many paper books will be filed.
Lordship, I'll submit.
Give the format of the requisite number of paper books in the department. Next. If you want.
Lordship, I appear for the petitioners, appellant. So, can one is the petition for condonation of delay.
So give serve notice.
Lordship, I have already served. They have filed the affidavit in. There is a direction for filing affidavit in opposition. They have already filed. I have filed my reply also.
So Monday.
Grateful, Lordship.
So as for appellant, nobody for respondents, Monday. Next. 52. 52. Nobody appears. Monday.
Lord, in 53, I
It
appear.
is barred by out of time. Steps be taken.
No.
When
Lord, a week's time.
next available circuit.
I'm deeply obliged.
Next. 54.
I appear for the petitioner in 54, Lordship.
Yes.
Lordship, the can one is the application for injunction. This is a partition suit matters, Lordship. My suit for partition was dismissed. And I
Can one is for?
Petition for injunction.
No injunction is in view of the nature of.
Partition, this is a partition, Lordship. Kindly allow me.
No way. The single judge, the trial judge has held that you have no particular interest in.
No, Lordship, this is not the fact. Lordship, they are admittedly we are
All
the
right,
court.
copy of the injunction application be served upon the respondent.
So, sir, I have already served. There is a direction to serve. I have already
Fresh
served.
service, nobody appears for respondent, fresh service. We are not going to give any injunction order on a partition suit which has been dismissed. Next.
But this is the first appeal.
Yes.
This is my shoot for specific purpose of the oral agreement that was dismissed. I filed injunction appeal, there is no scope injunction.
In view of the appellant as a sale, in view of the impugned judgment, we are of the opinion there is no scope to pass any interim relief. Application for injunction is accordingly disposed of. Appeal is admitted. Requisite
I give the
call notice upon the issue notice upon the respondents. Call for TCR. Requisite appellant shall submit requisite number of paper books. Please, Mr. Wright, give the format.
Yes, I have that.
Next.
Item number 56 and appear on top of the appeal and lordship. Lordship, there is a defect, lordship. I have to annex the decree of the order, lordship, as Darjeeling court is on vacation, my lord. On 27th, it is reopened.
Next available circuit.
Great.
On the prayer of the appellant, placed before the next available circuit. In the meantime, defects be removed.
Great.
Yes. Next.
My lord, item number 57, I am appearing on behalf of the appellant, my lord.
So I'm for the respondent. I filed caveat, but no memo, copy of memo has been given.
My lord, this is the second appeal. To be very honest enough, I haven't received any caveat from their side. My lord.
Memo be supplied.
My lord.
We keep it next week.
Next circuit, my lord.
Next circuit.
I'll be going to hello.
All right, next available circuit. On the prayer of the appellant, next available circuit. Next.
My lord, one indulgence before your lordship with my quoted. Let a copy of the caveat be supplied to us.
We are not passing any order. In the meantime, please give him caveat, give a memo. Yes.
This item 50 and for the applicant, Lordship. Lordship, there is defect in this matter, Lordship. We've just been handed over this matter, Lordship. We may pray for next circuit.
Defects be removed, placed before the next available circuit.
Deeply honored.
The Lordship kindly see the defects. My lord, I have gone through the defects. Lordship only see the second last paragraph of the defects written by the stamp vendor.
59, there is no note for defect. Amlan Chaudhuri. Let me see.
Lordship, please, the nature of defects that can be rectified by sending down the file to the court below.
Where is the defect?
No.
There is no, let us see the stamp reporter.
Yes, your lordship. I have taken.
কোনো defect নেই. Just see.
Yes, your lordship. This defect cannot be cured by me, lordship.
All right. Peruse the stamp reporter's report. Peruse the report of the stamp reporter. Records be sent down to the trial court for removal of the defects. After removal of defect, the records be retransmitted to this court within 4 weeks.
Lordship, I'm extremely grateful.
Next. 60.
Can you accept this matter on Monday?
Monday.
Get-
61. Monday. 62.
Well, I'm not ready. I'll take it Monday.
Monday
Second appeal.
or next available circuit.
No, I'll do it
Monday.
lordship.
Monday.
Until-
On prayer of appellant, Monday. 63. Nobody appears for appellant, adjourned till Monday. Same.
For next circuit.
Next circuit on the prayer of the appellant, next available circuit. Nobody appears for appellant, Monday.
I'll pay for next circuit, Lordship.
On prayer of appellant,
Yes, Lordship.
next available circuit.
Good.
Next.
For the appellant lordship. Matter relating to the order 41 rule 11.
Yes,
Affirmed order lordship.
I found. So we'll consider it Monday,
Monday.
Monday on the prayer of appellant, Monday.
Lordship, item 67, I'm appearing on behalf of the appellant. Lordship, this is the first miscellaneous appeal arising out of an application under section 8 of the Hindu Minority Guardianship Act. Lordship, in this informal affidavits, there was a direction to serve informal affidavits. They have all been served.
Respondents are appearing?
They have been served, Lordship. They have been served. They have received a notice. There was an order to that effect, and also they have been served with the affidavit of with the informal paper, copy of the informal paper. Also, at the time of
Anyone
filing,
entered appearing?
no, they have not appeared as of now. It's proceeding. It's going on expiry, Lordship. As of
Please give fresh notice. Fresh notice upon the response.
I have the already, Lordship. Then kindly fix it on Monday, Lordship.
Monday.
Grateful, Lordship.
Nobody appears Monday.
69. I'm
68 next available circuit. 69.
69. I'm not pressing this appeal now.
Appellant does not wish to press the appeal. Accordingly, appeal is dismissed as not pressed.
Grateful, Lordship.
Next.
But at 70,
Defect.
my lord, there is defect and a defect is, my lord, that kind of nature, my lord, defects in with regard to the decrease of the trial.
Right. In view of the nature of defects, the records be sent down to the trial court to correct the defects. After correction of defects, the records be retransmitted before this court within 4 weeks of receipt of the records.
Grateful.
71 and 72 I'm not pressing.
Not pressed, dismissed. '73. Monday.
74.
Same.
75.
But 74 my lord, I'm for the appeal.
74, we are keeping it on Monday.
75.
Monday.
76.
76
Defects
defects have not been cured, my lord. If a week time be given, my lord.
Defects be removed. Place the matter before next available circuit.
Grateful.
77.
I'm praying for next circuit.
Next available circuit.
78.
Monday.
79.
Well, I'm for the respondent, my lord.
So and so appears for the respondent, nobody for appellant. Fix on Monday.
My lord.
80.
Nobody appears Monday.
81.
81 not pressing. Sir.
Not
I'm not
pressed.
pressing.
Not pressed.
Appeal, my lord.
82.
Praying for next.
Next available circuit 82.
83.
Monday.
Not pressed on.
Nahi. 83.
83.
83 I'm not pressing.
Not pressed.
84.
84 is a new matter. Mala stay has not been filed. Next circuit.
Next
Mala.
available
Next
circuit.
85.
85 also not pressing.
Not pressed.
These are all against the identity man. I'll come to fight it out in the court.
83.
86, my lord, Mr. Mohinur, someone is appealing for the appeal, my lord. There, it has also defect, my lord.
It has?
Defect. Mr. Rahman is appealing for the
All right,
appeal, my lord.
defects be removed. Next available circuit.
Grateful.
87.
Not this week, Monday.
88.
88 to FAT গো এইখানে এলো কি করে অর্ডার 41 এ FAT এর দেখো তো হ্যাঁ এগুলো FAT এখানে এলো কি করে একটু দেখে নাও এগুলো তো অর্ডার 41 এ আসছে কি করে হ্যাঁ তো আগের ডিরেকশনে অর্ডার 41 এ আসছে কেন একটু দেখে নিও মানডেতে রাখছি যদি হয় এতে অ্যাডমিশন অফ অ্যাপিলেট যাবে হ্যাঁ মানডে 87 88 89 মানডে
89 and for the copy has not been
respondent
I'm respondent.
right let them come
Let them,
this is the first appeal though
first appeal.
so why is it coming under order 41 heading
No.
these are not first miscellaneous appeal Mr. Rai it is FA
Okay.
it should come under the proper heading
No, admission already been there. Admission already been done.
so
Right.
then why order 41
So,
all right
it has been
Monday let them come we will see
My lord, can we fix on Wednesday? Wednesday.
all right
Wednesday.
89 Wednesday
Lordship.
yes 90
90.
Monday
91.
Monday
92.
Praying for next circuit, my lord.
next available circuit
Grateful.
93.
Respondent and directed, I'm here for the respondent, so I directed him to file the proposition, my lordship.
what administrative tribunal order what if it is in opposition Monday we'll see what is the matter Monday.
94, my lord. I am for the petitioner, my lord. I am praying for next circuit, my lord.
Next available circuit.
95, I am for the appellant. My lord, kindly fix the next circuit.
Next available circuit. 96, 97. Who is for the appellant in these death reference cases? To be mentioned Monday. 96, 97 and 98, 99. To be mentioned Monday. এবার ক্রিমিনাল অ্যাপিল গুলো না পেজ ওয়াইজ করো তো।
One indulgence, I apologize, Lordship. If kindly item number 67 can be fixed next circuit, Lordship.
Which is 64?
I've prayed for next week, Lordship.
We'll consider it then, right?
All right, Lordship. Grateful.
100 to 122 criminal appeals.
For 100 for the appeal as well. Kindly fix
Monday.
Appeal against technical.
All are Monday. We are keeping all these on Monday. 100 to 122 Monday. To 141.
Lordship, item number 113, kindly next circuit, your lordship.
113 next. 113 and 14 are there.
113.
Sir, 113 is with 114. So both next circuit. Other matters?
Item number 112, next circuit.
112 next circuit. Yes. 123 to 141.
Lordship, 124, direction was given for the paper book. The paper book not yet ready.
All right, paper books are not ready. No, there are paper books, 2 paper books, 124.
But
Sir, there is paper book, let it be Monday, nothing more.
Your lordship, item number 127. 127.
Yes.
Next circuit, your lordship.
Huh?
Next circuit.
127 next circuit.
Yes, your lordship. Grateful. Your lordship. 134, your lordship. Item number 134. Next circuit, your lordship.
142. Who's there? Monday. 143.
43, but I am for the respondents.
It's appearing for the respondents.
Yes.
Formal paper books have been filed, is virtually available.
Which one?
43.
In 143, my lord, I am
Yes.
appearing for the respondents.
All right. We are keeping it on Monday.
Very well.
Monday.
Obliged.
Nobody appears for the petitioner. So and so appears for respondents. Adjourn till Monday.
Obliged.
144,
Monday.
125,
Monday.
143.
It's an appeal, my lord. Hearing of bad appeal.
So next available circuit.
Bad case.
On pair of appellant, next available circuit. Yes. 147, 148. Monday.
139.
Well, I am for the respondent.
So and so for respondent, nobody for appellant. Next available circuit.
Well, let it on Monday. Monday.
Next available Monday.
Grateful.
150.
Next available circuit.
151.
My lord, this matter, my lord, I am appealer, my lord. Matter, my lord, I intend to proceed with this, my lord.
Which one?
51.
Not this week.
Not this week, Monday, my lord.
Monday.
Monday, my lord. Grateful, my lord. Not this week.
Next available circuit. Next available,
Appearing on behalf of the respondent, your lordship, in this matter, there was a direction to file the paper book. The appellant has failed to file that, your lordship, and it is pending for quite some time. They are not appearing, your lordship.
next available circuit. Nobody appears for appellant.
Kindly fix this matter on Monday, your lordship.
Monday, 153.
Your-
Nobody appears for appellant. Next available circuit. Same.
For that.
So and so for appellant. When do you, this circuit you want to do or next circuit?
This.
All right, Monday.
Grateful lordship.
Nobody appears for appellant. Next available circuit.
My lord, I am appealing for the respondent number 1. My lord, there is also direction of paper book, no states.
Nobody appears for appellant. Respondents. So and so appears for respondents. Next available circuit.
158, appearing for next circuit.
On appellant, next available circuit.
159.
We appear for the respondent. That will be heard in Monday.
Next available circuit.
But this is.
Nobody
paid
appears
quite
for
long.
appellant, so and so for respondents, next available.
160.
60. Nobody appears, next available circuit,
161.
same,
162.
same,
163.
same,
Appearing for next circuit.
same,
165.
same,
163.
same,
167.
same,
168 and 169.
same,
170.
170, next available circuit.
Well, can you hear this matter? Say, Mandamas appealing, they, my lord, say point of law is, local stand is question only, my lord.
Next circuit.
Kindly, my lord,
Too low in the,
any day.
all right, Monday.
Monday, well, can any day, my lord.
Next,
170.
next available circuit,
172.
next available circuit,
173.
same, same,
My lord, 175 and 176 is a cross appeal, my lord. If your lordships can take it up any day after Tuesday, from Tuesday onwards, then Mr. Devashish Kundu will be appearing, my lord. He has made a request, my lord. If it can be taken up, not on Monday, my lord, any day after that.
Thursday,
Great,
Thursday, if you get a chance.
please.
Ask Mr. Kundu. We've got these two death
lord,
reference.
my
We
lord.
will start the hearing of the death reference cases next week, so we won't get time for the Mandamas appeal. We don't know, nobody's appearing, so we keep it on Mondays to be mentioned, then we will see when. if
My lord, item number 78, my lord,
some order has been passed, in all probability Monday, please check out.